Hey, please, your lawsuits. Let the matter be listed on Friday, my lord. Case is 2021, my lord. Non-payment of salaries.
Admission.
Admission. High level.
May I please? My lord, I beg to mention item number 14 and 15 of this.
14 and
15, my lord.
yes.
The consent of others said this matter may come after 2 weeks, my lord. Here, my lord, NJ Khatuni are looking after this matter. He is out of station.
14 and 15 on the request made on behalf of the review petitioners stands deferred to be listed after 2 months.
Hey, my lord, I may be allowed to call for the affidavit filed, my lord, by slip, item 29.
20?
29. The
When
affidavit
did you file it?
on 29, 7 and 31.
All right.
Please, your lordship. I beg to mention.
Subject to clearance of defects.
My lord, I beg to mention for listing a writ petition, the 2nd week of August.
Admission matter.
Admission.
All right. 17th.
Obliged.
May please. My lord, I beg to mention for item number 39.
1-3.
1-3. Kindly allow me to review
Hmm?
this. Yes, my lord.
Withdraw.
Yes,
Withdraw the matter.
yes.
The order has been complied.
I don't know, my lord. The client has instructed to my senior to.
Item 13 on the instructions received. Counsel for the petitioner, Mr.
M. Hussain.
M. Hussain,
Yes, my lord.
submits that the petitioner does not wish to press the writ petition, the contempt petition any further. Accordingly, he submitted that the contempt petition be closed. Considering the submissions coming from the petitioner, that this contempt petition be closed. This is, if any issue, be recalled. Yes, most.
Most of it.
May it please your lordship. Lordship, I beg to. May it please your lordship. Lordship, I beg to mention for listing a matter for admission, lordship. Similar matter fixed on 12, lordship. 12 of August.
12 of August.
Lordship.
12 of August.
May I
Oblige,
please, lordship, lordship, I beg to mention item number 60.
Item
60. We will
60.
file additional affidavit for reply.
Hmm?
We will file additional affidavit for reply.
Item 60 on the request of the counsel for the petitioner stands deferred for
1
3
week.
weeks.
1 week.
3 weeks. Be listed after 3 weeks, enabling them to file rejoinder affidavit.
Okay.
Hey, please, your lordship. Lordship, I beg to mention for listing of a matter for orders.
When?
Well,
When do you want it?
on
17th.
7. Please, your lordship. Lordship, I beg to mention a matter for listing for admission, lordship.
17th.
2 matters. Similar matters.
17th August.
Lordship, can it be after 20th, 24th or 25th?
All right, 24th August.
Much obliged, lordship.
IA for implement, lordship.
IA for implement.
So, Mahesari party, lordship.
Which matter?
Which matter, lordship? Some Mahesari parties were required to be.
You have filed it.
Yes, lordship. This week if possible, lordship. Some artists.
This week. 5th.
Much obliged.
Yeah, please, your lordship. With regard to item number 19, we need 1 week time, lordship, to file a
19.
reply. Yes. File a reply, lordship.
Item 19 on the request made on behalf of
Petitioner.
petitioner.
Yes, lordship.
Matter stands deferred to be listed after 2 weeks, enabling them to file rejoinder affidavit.
My please, your lordship. So I'm praying for listing it 2 matters, lordship, for orders also. After
Sir.
20, lordship.
After 24th.
Obliged.
I'm going for listing one motion of.
When was it filed?
Okay, I will get the filing number in 5 minutes.
All right. 5th.
I am appearing item number 1 in.
Is there any instructions, Mr. Bhuya?
Yes, my lord, item number, if your lordships take up item number 2, in that case, similar stated, item number 2 to Diba. We have filed our detailed affidavit also, my lord. This is with,
This affidavit will cover the stand?
yes, all the, sir, all the
Oh.
matters. What happened in this case, my lord? A departmental promotional committee was there. And before that gradation this gradation list was asked to be prepared every district wise. 3 districts is okay, my lord. And it's been done and it's reached the logical end. So far, Baksa is concerned. Now, my lord, many persons being aggrieved approach this honorable court. And by this honorable court's order, certain rules has not been complied with. And as such, their case has to be reconsidered with that direction. It has been disposed of. And several other writ petitions were also there. Then, after going through everything, my lord, it could be ascertained the rules with regard to departmental promotion and all is not been, my lord, followed. And as such, the BTC has taken a conscious decision to cancel everything and start from afresh. And challenging that, my lord, this writ petition has come.
My lord,
You want to file a rejoinder or something?
my lord, I have not given the copy.
Not been given
Item
copy.
1, 3, and
So what I'm on, my lord, let it be a fixed date. We are not filing an affidavit to each and every cases. Item number 2, my lord, that affidavit which you have filed will serve a copy to 1, 2, and 3. That will do.
The heard learned counsel for the parties. Mr. Review, Senior Counsel, assisted by MSN Chaudhary, appearing for the PTC authority, submits that the detailed affidavit has been filed in WPC 1987
Yes.
of 2026, which reflects the stand of the BTC authorities. The learned counsel submits that they would like to rely on this affidavit in respect of all the other writ petitions. So, Mr. Chauhan on the other end, hearing in
1, 3, and
1, 3, and 4, item 1, 3, and 4, number submits that a copy of the said affidavit supplied, to which Mr. Bhuya submits that he will do so within the period of 3 working days. In that view of the matter, that these matters be listed for admission after 3 weeks.
My lord, next week also, only, my lord, today only I will serve the copy.
But they may like to file a reply.
My lord, in that case, 2 weeks, my lord, will
Right,
sufficient.
matter be listed after 2 weeks, by which date the petitioner may file a rejoinder affidavit. The affidavit filed by the PTC, which affidavit will be accepted to be an affidavit filed in the matters which Mr. Chauhan also appears. We list this matter again after 2 weeks.
My lord, a date may be fixed, my lord. After 2 weeks.
2020.
20 my lord.
There is some interim order. Is there any interim order?
yes.
Interim
Status
order.
quo order.
Interim order, item number 2, 3, and 4.
Interim
One
orders wherever passed will continue till the next date of listing.
Problem.
Yes. Bar Council.
I would say Bar Council, I found the only against this case because it is
You are for which?
for the Bar Council, Assam, Nagaland, and
Yes. There is a direction, the petitioner is seeking the pass certificate
yes,
from the college.
from the police. Because he did not receive, the petitioner did not submit the LLB certificate, we go to Bar Council. They,
So who is for the
Yes.
college?
he just,
Earlier, PJ Secretary.
he just,
PJ Pukul.
That we have the instruction, but I believe that the matter will be taken after some days.
No, we want to know if you are appearing for the university or for the college.
University.
That
For-
is,
both
what
for
university?
Both for university and college. University law, not Nalbari law.
You want a certificate from where? Nalbari?
What university? University Law College.
Then why did you array Nalbari Law College?
Because earlier Nalbari Law College did not have affiliation. The petitioners joined in the classes conducted by Nalbari Law College.
Under university.
Under University Law College. It was approval from Gauhati University.
At 2 p.m. At 2 p.m.
So his timing was, I guess, council.
2 p.m.
In this case, petitioner's name has been deleted from the Shikha Setu as well as 2 months salary has been.
Instructions any?
No, Your Lordship, instruction awaited, Your Lordship. On the last occasion, it has came, Your Lordship, communication has made. Kindly grant us 2 weeks' time, Your Lordship.
Even school is today.
Notice has not been issued.
Notice needs to be issued. We thought you can get instructions.
Yes, Your Lordship.
They are unable to present in the school lordship because Shikha Setu, their name has been deleted from the Shikha Setu lordship. How
But
they
then we'll issue notice here. Heard Council for Parties issue notice, return of 3 weeks. MSP Das appears for
1, 2, and 4.
1, 2, and 4. Mr. Pegu, you are a state council. Or number 3. And since the respective council represents respondents 1, 2, 3, 4, notices of the extra copies will be furnished within a week. Steps on respondent number 5. You're on caveat. Respondent 5 is represented by Mr. M. Khan, who has entered appearance on instructions and therefore no notices, formal notices are waived. Extra copies be served on all the council appearing for the respondents within 3 working days.
one fair lordship. In today also school is open lordship is going on. How they will lordship? They are present in the school, but their present is not enlisted in the Shikha Setu lordship. So interim fair maybe lordship they are present.
Next date, Your
No
Lordship.
action shall be taken against them petitioner because if the headmaster or school inspector lordship after the appearance lordship this period lordship they without nothing lordship if they included that they have absent.
It is submitted that because of their names being deleted from the Shiksha Setu,
Shikha Setu.
the petitioners, although are presenting themselves for their services, they are not allowed. Their presence is not recorded by the headmaster of the concerned school. An apprehension is expressed that later the school may take action against these petitioners on the ground that they did not attend their duties. So, such submission of the petitioner is taken on record. It is made clear that any further decision or action sought to be initiated against the writ petitioner shall not be done without leave of the court during the pendency of the writ petition.
Your Lordship, they are unauthorized, Your Lordship. Already did. This is the only thing, Your Lordship.
We are saying that don't take any further action without leave of the court.
Your Lordship.
Yes.
Here the petitioner had the teaching and non-teaching staff of a higher secondary school under Hailakandi district minor. The high school of the petitioner, the high school up to high school level, the school was provincialized in the year of 1985. On 2000, my lord, from 2000, the managing committee of the school decided to introduce the higher secondary section in the school. Accordingly, the petitioner was appointed by the school managing committee, my lord. And they are working from 2001 till date, my lord. In the meantime, my lord, on 2005, my lord, the higher secondary level was got permission, my lord, accord permission, that is Annexure 10, type copy, page 78, my lord. That is the first one is 78 is type copy, my lord. And
You are challenging the order at 105.
yes, my lord. The petitioner has earlier approached before this court, and this honorable court directed to scrutiny the matter and passing a necessary order, my lord. Thereafter, after pass this honorable high court order, nothing has been done, and petitioner filed a contempt petition which is pending before this court. In the meantime, the respondent authority passed a final order whereby it was stated that the school did not have any permission from SEBA, that is that their prayer cannot be considered. And thereafter, the inspector of school, he issued an order that the petitioner were not allowed to take classes as they are unauthorized person. How they can be unauthorized person, although they were appointed by the school management committee and working from last 2000 to till date, my.
All right, we will issue notice in the matter. Third, counsel for the petitioner. Issue notice in January 4 weeks. And speed us.
1, 2, 3, and 4.
The standing counsel in the education department appears for respondents 1, 2, 3, 4, and 5.
4.
What about 5 and 6? It is elementary. Who is for elementary?
5 and 6 5 is elementary and another is headmaster, your lordship. Inspector of school,
Alright.
Hailakandi.
5, who's appearing for 5?
I'm appearing, lordship.
MSS score appears for respondent 5. Therefore,
Head-
notices, no formal notices will be issued. Respondents,
Six.
respective respondents 1, 2, 3, 4, 5. Notices are waived, extra copies will be furnished within a period of 1 week from today. Steps on respondent 5 by speed post within 1 week from today.
By this order passed by the inspector of the school, they are not allowing to classes
Which order?
by 115 page number 19.3 or 19.6 2006. The classes
Let the notice me go, your lordship will obtain instruction, your lordship.
as they are not allowing to take
Where
classes.
is the order of the inspector?
Academic inserts, my lord. Academic insert. Thereby they are not going prevent from taking classes. As a result, the student is suffering, my lord. Let them functioning the classes, my lord. As they are working for last 26 years. They are saying that he is saying that they are
Then-
unauthorized person.
Venture group of teachers in the academic section 2026 to 2027, your lordship. Let the instruction may obtain, your lordship, in the whether they are unauthorized or authorized, your lordship.
Yeah, so I have annexed the appointment letter, joining letter.
Today is the first day, your lordship.
The appointment appointed by the managing committee cannot be unauthorized.
Or issue notice on the interim prayer, returnable on 24th. We'll consider your prayer on the 24th.
Deeply opposed.
Huh? Good. We'll issue notice.
My Lord, we are praying for an interim also, my Lord.
What
I'm
interim?
still, my Lord, because this impugn speaking order, my Lord, which I am challenging, my Lord, is prima facie and ex specie illegal, my Lord.
Which order?
The impugn speaking order is at page 45 to 46, my Lord. Annexure 10. My Lord, this is a long order. This is in respect of my deployment. My Lord. They have not transferred me, rather they have deployed me like an army personnel, my Lord, not as a teacher, which is not permissible. My Lordship knows, my Lord.
Where is the deployment order?
Yes, my lord may be pleased to find the deployment order, my lord, is at page number 28, my lord. And my name, my lord, may be pleased to find serial number 5, my lord. Sub serial 3, my lord.
What is wrong with this order?
My lord, may kindly see, my lord, as per the approval of the Office of the Director, Secondary Education, Communication, letter number dated, the following teachers are hereby deployed in the newly constructed model schools for its smooth functioning, and they are directed to report and joining the day of regularization. My lord, when this deployment order was, my lord, issued, and my lord may kindly see from serial number 3, I had been deployed to Vivekananda Vidyalaya Higher Secondary School, Digboi. Now, my lord, this is wherein, my lord, I am working, and my lord, I have been deployed to Savitri TE Model School, which is at, my lord, just, my lord, the left side column, my lord, name has been mentioned. So, my lord, I am working at present at this Vivekananda Vidyalaya Higher Secondary School, Digboi, which is purely an English medium institution, my lord. And as per the rule, my lord, when the advertisement is floated, there is a condition that those candidates who can teach in English, they have to apply, my lord, in the English medium category. If my lord maybe just for a moment is please to take up the advertisement, my lord, which we have made as a last annexure, my lord, may kindly turn to page number, my lord, 65, annexure 13, my lord. Advertisement dated 27/12/2022. Now, my lord, the relevant part which I am relying on is at page number 67, clause 5, my lord. Here it says, my lord, that in case of English medium school, the candidate must have passed HSLC or the equivalent examination with alternative English as one of the subject or read from class 9 towards in English medium schools, my lord. So this is the specific category of the candidate that this is required to be fulfilled. Now, my lord, basing on this advertisement, I did apply. My lord may be pleased to find my application from, my lord, is at page 12, my lord, page 63, annexure 12, my lord. So, my lord, when I applied for the post of the graduate teacher time, science, district applied medium of school, Tinsukia and English medium, my lord, I have applied. So, my lord, there is no connection with me that I can, my lord, instruct the education of the such an important subject of English. So, therefore, my lord, when this deployment order had been issued, my lord, I raised an objection, my lord, that I cannot, my medium cannot be shifted or converted, and which is also a mandatory requirement of the 2018 rules also, my lord. If my lord, may be pleased
Let
to-
them obtain their instructions.
Yes, my lord. Still, till then, my lord, I am working in this school, so my lord, I may not be face any coercive action because, my lord, I have not been allowed to put my signature today also, my lord.
So what is the point then?
No, my lord. Though, my lord,
Your official order says you have to go and join
no,
there.
I have to go there and join, my lord. If my lord may be pleased to take up the rule, my lord, this is an absolute violation of the 2018 rules, my lord.
Let's see.
Yes, my lord. And as well as, my lord, also violating the PTR condition also. Rule 10, sub rule 5, my lord, of the secondary education provincialized school service rules, my lord. My lord may be pleased to find this.
Yes.
My lord, this rule 10, sub rule 5, my lord.
Rule 10.
My lord.
Okay.
Lord, which says sub rule 1, my lord, 1 to 4, that the Assam secondary says, my lord, that the petitioner applied.
Let them get their instructions because
My
you had come before the court earlier.
I have come, my lord. There is a direction has been passed to, my lord, consider every aspect of the matter, my lord. But in the impugned speaking order, many matter has not been considered, my lord, including the condition of this rule also, my lord. That is missing.
Regarding that, I have to take instruction and
Yes.
so sometime maybe get it was take instruction.
You take instructions.
Yes.
Third, Mr. A.R. Mia, Learned Senior Counsel, assisted by Mr. Z. Chaudhary. Mr. U. Sharma, Standing Counsel in Secondary Education. Mr. Sharma is permitted 2 weeks' time to complete his instructions on the deployment of the writ petitioner from his parent school to model school in the T estate.
My lord, this is Sabitri
Sabitri.
TE model school, the same district.
Sabitri TE model
Model
school,
school, which is an Assamese medium school.
which is an Assamese medium school.
My
It is the submission of the senior counsel that petitioner is subject teacher. You're a subject
No, my
teacher.
lord, I am a graduate teacher science in English medium.
Graduate teacher science in English medium school at Vivekananda School in Digboi, and he is being transferred, deployed
Deployed.
to Sabitri model T state. Sabitri, what is that?
Sabitri TE model school. T estate.
Sabitri TE model school
Model.
in the same district. It is the submission of the senior counsel that this violates the provisions of the rules of 2018.
Model.
Inasmuch as the petitioner does not have proficiency to render services in an Assamese medium school, as has been sought to be deployed. So his writ petition earlier was disposed of by directing the respondent authorities to consider the grievances and pass appropriate orders. Stop. Thereafter, by order dated 17/7/26, the order was issued by the Director of Secondary Education, rejecting the representation. Stop being agreed. The petitioner will be scored. The State Council will obtain instruction in the matter. Matter will be listed again after 1 week.
10 days, my lord.
10 days. 17th.
Fine.
And let the counsel for the petitioner serve an extra copy
Yes.
on the council, standing council for education within 2 working days.
My lord, some protection, my lord, because my lord, I have not been allowed.
The
My
prayer for interim will be considered on the next
lord,
journal.
no coercive action may be taken because my lord, I have not been allowed to put my signature in the attendance. Kindly, my lord.
Not be allowed to, but
No, because my
consider
lord,
it.
this order, my lord, is expressly illegal. Otherwise, I would not have pressed, my lord.
We have not found it to be expressly illegal.
Because, my lord, the rule from Assamese to English, my lord, or English to Assamese, there is no provision for shifting of teachers, my lord. Because it will defeat the RT also, my lord. Because if I go to Assamese medium, I cannot teach the student there in my lord. My lord.
For what subject are you carried?
My lord, I am a science teacher graduate, my lord, and English is my lord, main subject. In which, my lord, I have to instruct in English medium, my lord.
There is
Let
no
the
such thing.
obtain instruction.
You will get the instructions,
Yes.
take it up.
My lord.
You get it in a short date. Why do you want 10 days for the instructions?
10 days is required, my lord. Because it will come from Tinsukia, my lord.
No,
In
Director
India.
of Secondary.
Where is your representation?
Lord, my representation is not reply dated. My lord, may be pleased to find is at page 35. And after the order, my lord, I have made specific representation start at page 41, my lord. Including, my lord, my medical condition has also not been considered, my lord. But I have been recently operated, my lord, of hernia, my lord.
There is no ground here taken in the representation that Assamese medium, English medium, you can't teach.
No, no, my lord, this is the, my lord, issue of, my lord, law, my lord. This is the issue of.
That's right, but
That is right, my lord. But,
unless you
my lord,
urge
in
it before the
in
authorities,
hearing, my lord, when the
unless you urge it before the authorities,
the hearing had also been taken, my lord, and I have specifically urged before the authority, my lord, it will defeat the, because if I go there.
it is not there in the order. That's what we're
No,
trying
my
to
lord.
tell you.
My lord, may kindly appreciate, my lord.
If it is not there, the authorities,
No, my lord, when the hearing was done, my lord, I have specifically, my lord, orally submitted that I cannot teach the, my lord, in English, in Assamese medium school, my lord.
there is no such finding here.
My lord, in page number 30 also, my lord, the representation which I have made earlier, I have specifically made this prayer, my lord.
Where?
At page 30 to the inspector of schools also, my lord, I have made serial number 1, my lord.
Your ground essentially was health ground and
And my lord, this rule violation is also there, my lord. It's a question of law, my lord. Statutory prescription has been violated, my lord.
where is the statutory violation? I fail to understand that.
Rule 10, if my lord, if we
This
go
page
by,
number 31.
my lord, if we go by the advertisement, my lord,
Mr. Counsel, it's a question of deployment.
my lord.
So we are on the issue of whether this deployment is proper or improper. You had come before the earlier, the court before, you have urged the matter was remanded back.
My lord.
You have accepted this order
Yes, yes,
of
my
the
lord.
court.
Yes, my lord. Yes,
And then on the representations file,
my
the representations do not indicate that you had raised this issue before the
my
authorities.
lord, we have, my lord, in earlier also I have raised before the inspector of school as well as during the course of the hearing, my lord. I have specifically.
That is neither here nor there because there is no record of it.
No, my lord, the
The order does not reflect it.
No, my lord, the entire record from the inspector of school had also been called for by the director, my lord. A long, my lord, several dates of hearing had been done, my lord. And my lord, if you go by the provision of the advertisement also, it has been violated, my lord.
No, where do you say the provision? Which provision of which rule?
My lord, the rule 10, sub rule 5 of the, my lord, secondary.
It does not show that you are not there. You are not appointed to this school on a permanent basis. You are only deployed.
No, no, my lord, my service and my duty is to teach, my lord. And if
That's
we go, if I go there, my lord, and if I cannot teach the students, my lord, in Assamese medium, my lord,
This
then
is the prime ground you should have urged before the
no, my lord,
authorities.
but my lord, my lord can always have, my lord.
Did you urge it before the court?
Yes, yes, my lord. I have urged before the authority also, my lord. Now, first time, my lord, this has been urged before my lordships, my lord. After the authority, when I urged, my lord. My lord, I kindly appreciate it will defeat the, my lord. Students will also going to suffer, my lord. Not only me. Because, my lord, I have checked the textbook.
You come to page number 38.
My lord.
This is an order which is recorded by the coordinate bench.
My lord, I
Kindly
have
read
not-
the order and say that you have raised these issues before the court earlier.
No, my lord, earlier this issue was
Then-
not pleaded, my lord,
then-
but the verbally the submission
No,
was
no,
made.
then where is the question of pleading it now and saying that this is the issue which was not considered? You came before the court, you are at your best to decide what grounds to urge. You should have urged this ground.
No,
If this is your primary ground, you did
My
not.
lord, the honorable court direction, my lord, if we go by the honorable court direction, my lord, paragraph 6 says, taking into account the submission made by the parties and on perusal of the materials available on record, this court is of the considered view that the respondent authorities should consider and dispose of the representation of the petitioner by a face speaking order.
That has been done.
My lord, since the petitioner has not disclosed any supporting documents of this so, my lord, I have, my lord, placed all the materials, including
All
my lord,
these
although I
pertain
have,
to
my
your
lord, my
medical difficulty.
lord, I have to submit fairly before my lord. This specifically regarding the changing of the medium has not been pleaded in my petition.
Then we'll have to
But
examine it.
But my lord, this is a question of law, my lord.
Exactly.
So
we
therefore,
are not foreclosing your arguments.
No, my lord, that's why, my lord. At least, my lord,
The question of law you have to satisfy that
my
it
lord,
is out and out on the prima facie, it violates the rules of the act
Exactly, my
or
lord.
a judgment of the court.
Exactly, my lord. The rules has been violated.
No,
my
it
lord.
has not been violated. You show us.
My lord, the rule 10.
Prima facie, we don't find it. 2003 rules.
2018 has been amended, my lord.
2018. What page number?
The page number 363, it starts. I have marked it somewhere also, my lord, but
This is 2003 rules.
yes, my lord, this 2003 has been amended in the year 2018, my lord.
Where is the 2018 rules?
Lord, as amended in 4th of August 2012, my lord.
My lord, page 19. Page 19 or 20, and here my lord, the rule is page 30
Oh, yes,
and 31 is sub rule 5 in addition.
my lord.
Rule?
My lord, we are relying on Rule 10, Sub Rule 5, my lord. In addition to the academic and professional qualification, in case of Assamese medium school, the candidate must have passed SSLC or equivalent examination with Assamese language as one of the subject or having diploma in Assamese language, so and so, so and so. In case of, my lord, English medium schools, if they rule sub Rule 5, my lord, the candidate must have passed the SSLC equivalent examination with alternative English as one of the subjects or read from class 11 onward in English medium schools. So therefore, my lord, I have only this efficiency and proficiency of rule.
We'll examine it.
My lord,
We'll examine.
my lord, examine, my lord, may kindly give
No,
some protection, my lord.
We can't give you any protection today. We can
No.
keep it on the basis of their instructions available. We can reconsider your prayer for interim. Not today.
My lord, I am also, my lord, physically ill also, my lord. If I
You take leave.
my lord, if I put in
You
there.
are a government servant. You have leave,
I have
you
to
medical
go.
leave.
My lord, if rule or my lord, if rule do not allows or support me, even I will not make, my lord, submission for the interim stay, my lord.
We will consider them, give them an opportunity. You had come before the
My
court.
lord.
You
My
had
lord.
filed your representation for the authorities.
My lord.
Nowhere you thought it fit to raise this objection that this
My
is
lord.
violative of the rule. You are unfit
My lord,
to
that
take
is-
classes in
My lord,
Assamese media.
Sometimes it happens, my lord, when petitioner.
So,
my lord,
right.
But my lord, prima facie, this is a violation.
Prima
of the-
facie, therefore, we are not satisfied because had it been raised before the authorities,
My lord.
then the authorities would have dealt with it or not dealt with it. Then it would have been prima facie clear to us. So we are asking him to obtain the
Then a
instructions.
short date may be given.
Short date,
My-
that we can do. Yes, 12. 10th,
Yes.
10th,
10th.
okay, 10th.
My-
Released on 10th, enabling the standing council to obtain required instructions. Council for petitioner is permitted to renew his prayer for interim on the next return of date.
My lord. Obliging.
You'll fund his extra copies within the day.
Yes, my lord, day itself.
Actually, in this case, my lord, the petitioner was appointed as the subject teacher in the Tamilpur Higher Secondary School in the year of 2011. While she was discharging her duty as such, my lord, in the Tamilpur Higher Secondary School. And then, my lord, one advertisement was published by the SEVA seeking seeking to fill up some post. Also, we find that advertisement at page 23, my lord. Page 23, A, capital A. Name of the post, Assistant Academic Officer in Boru. And having all requisite qualification, my lord, the petitioner has applied for that post, my lord. And after application and interview, my lord, she was selected. In the meantime, my lord, she applied for the legal leave for the concerned authority, the Director of Education, BTC, now BTR, my lord. And accordingly, on the basis of that application and her selection, the authority has granted the lien. Lordship will find that lien order at page 27, my lord, first lien order that has been issued and passed on 12 June 2017, my lord. First, my lord, first occasion, my lord, she was granted 1 year leave, my lord, and later on, my lord, twice her lien leave has been extended till, my lord, till 8/3/2019. But after joining in the SEBA as an assistant academic officer, my lord, she has not completed the complete gate period, my lord, and again come back to the original post in the earlier school, my lord. And lordship, can kindly turn to page 51, my lord.
Will issue notice here?
Yes, lord.
Third council party. Mr. U. Sharma
Yes.
appears for respondent number one. Only one.
Yes.
MS Borua.
Correspondent.
Respondent two, MS N. Chaudhary. Correspondent three, 4 and 5.
Five is the school, my lord. I have taken.
Huh?
Five is the
3 and 4. Therefore, notices on behalf of respondent 1, 2, 3, 4 stand waived. Extra copies will furnish in 3 working days. Steps on respondent 5 within 3 working days by speed post.
Obliged.
List after return of the day.
Obliged.
My lord, may I plead, my lord? My lord, with your permission, I'd like to give a brief of the matter, my lord. My lord, the petitioner is a minor child, my lord, 8 years old, my lord, and he was seeking admission at KVS Sivsagar, my lord. And he has been refused, my lord, by the authorities, my lord, because he could not qualify under the age eligibility criteria. There's a 16-day shortfall. My lord, the reason that this person who's actually from Mumbai is here in Sivsagar is because the petitioner's father is a government employee, and in as a government employee, there are certain exigencies, my lord, which is why he had to be transferred, my lord, in public interest, my lord, and not upon his own volition, my lord. Now, what happened, my lord, is that the petitioner's father approached the school, my lord, and he made a
He is
representation.
seeking admission in which class?
My lord, class 3, my lord. And
Class 3.
3, my lord, and the age limit is between 8 to 10 years, my lord. And because of the age eligibility date cutoff, my lord, which is
This
first
is
April.
between the academic year.
Yes, my lord, in between the academic year, my lord, and that is the only reason KVS were established in 1963, my lord, because of this only, my lord. That
Who is the standing counsel for KVS?
my lord,
Is there any standing
for that, my
counsel?
lord, deputy SGI, my lord, but other.
Yes. Any CGC? Any CGC? Call for a CGC. Yes. Are you standing counsel for KVS? Central government. Please take instructions here as to why the school is opposing admission.
My lord, representation was also made before the principal, my lord, and it was a verbal refusal, my lord, not even a written order, my lord. And further, my lord, an appeal was also made by the petitioner's father before the Department of Administrative Reforms and Public Grievances, but to no avail, my lord. Because, my lord, there was a vague answer by the portal, my lord, stating that the matter has been referred to KVS headquarters, and no date has been given as to when the problem would be rectified, my lord.
All right, you please get instructions here. You serve an extra copy today.
Yes, my lord. Obliged.
We
Obliged.
will post.
R.H. Chaudhary is, this is R.H. Chaudhary is for standing counsel for.
Then you give it to her. We don't know
I
who
will
is there.
inform. Yes.
Just inform them and ask them to get their instructions on 10th of August.
Obliged, my lord.
Third counsel for party, your Mr.
M. Hazarika, my lord.
M. Hazarika for the petitioner, MSR Bora, CGC. It's been requested by the court to appear for the respondent KVS as counsel represents the KVS. The petitioner is agreed by, petitioner is a minor represented by the father. Grievance is the refusal of the KVS authority to grant admission to class 2.
My lord, class 3, my lord.
Class 3.
Yes, my lord.
Standard
He was
3,
already studying in class 2.
or standard 3. The KVS Sipsagar
Yes, my lord.
for the academic session 2026-27. So, this submission of the counsel for the petitioner. The father of the petitioner is a government servant and was transferred to SAM of government service, which necessitated the transfer of the petitioner during the academic midterm for seeking admission in KVS Sipsagar. So we submitted that the authorities have verbally denied admission, but no specific order has been passed. Hence, better considering the submissions made, we permit MSR Bora, learner CGC to obtain the required instructions in this matter. Matter be released again on 10th of August. The extra copies we furnished on the learner CGC during the course of the day to enable her to obtain instructions. Okay.
May reason. Lordship petitioner library there Lordship was appointed Lordship in 2013 Lordship. She joined on 1st September 2015 Lordship. During this period Lordship, no advertisement was made Lordship. 2022 Lordship.
We need to notice here, right? Mr. A. Sharma, direct counsel for the petitioner, should notice 4 weeks. MS.
R. Sharma on behalf of the Upper.
R. Sharma appears on behalf of the Upamenu,
Standing Council for Higher Education.
Standing Council for Higher Education, accepting notices on behalf of respondent number 1, 2, 1, 2, 4, 5. Mr. Degu appears for respondent number 3. Therefore, notices, no formal notice need be issued to respondents 1, 2, 3, 4, 5. However, steps on respondent 6, 7, 8 by speed post within 3 working days. 1, 2, 4, and 5. We said 1, 2, 4, and 5.
May I pray for fixing a date Lordship?
After return of date, 7 September.
Yeah. Last state, the BTC Council was asked to instruction where this case is covered.
Is it?
Lordship, 2 days time, Lordship.
2 days. Why do you need 2 days? The judgment is reflected here. You see and tell us at 2 p.m. No, Wednesday.
Any day, Lordship.
Wednesday.
Wednesday.
Release this matter on Wednesday on the request of the BPC Council. Mr. N. Doctor, Senior Counsel, assisted by Mr. H.M. Ali appears for petition. And Chaudhary for BPC.
Last of it also, my lord, on behalf of Mr. D. Gogoi, time has been taken to take instruction in this regard, whether honorable court has order is complied or not.
Where is the order of the court?
Court, my lord, order of the court, page 10, my lord.
Page 10.
No, my lord, page, sorry. Page by lot 25. 25. Last paragraph, my lord. In view of the above, the present this program with direction to the respondent of the to consider a claim of the petitioner as per rules as mentioned above within a period of 3 months from the date of receipt of the silent copy of this.
Where is the Forest Council? Forest.
The go away here.
Yes, yes. Forest Council will keep it for the time being.
The brief, so here in this case, has been already short, so we can do this one.
Counsel for the petitioner submits that the petitioner's grievance has been addressed. Therefore, the petitioner does not wish to press the petition any further. Accordingly, the petition stands dismissed as not pressed. Interim orders, if any, stand vacated. Mr.
And KJ Saikia for respondent number 5.
KJ Soikia appears for respondent number 5, MSR Bora for
120.
respondents 1, 2, and 3. Disposed.
Deeply.
My lord, here the case concerns, my lord, a representation for regularization of service of the
Has
petitioner.
it been disposed of or not?
It has not been disposed of, my lord. I have been informed that they are not able to, my lord, trace out the representation. So, my lord, I am praying that let a fresh representation be filed, my lord. I will pursue the matter and get it, my lord, disposed.
Where is the representation?
Representation, my lord.
Twenty-one.
So 8 6 for 12 as well, my lord. 8 6, my lord.
Where is the
8, 6,
representation?
Page 22B.
22B.
Yes, sir. Annexure 8.
You ask your department to pass an order saying that
Yes.
the copy has been misplaced.
I will, my lord.
We do it within 1 week, failing which we are drawing up contempt proceedings.
I
Why
will,
are they sitting over it, not informing the court?
I will pursue this.
It is submitted before the court by Mr. I. Bodhaku, the standing counsel for the forest, that the directions contained in the order dated 2/8/2019 passed in WPC 4569 of 2014 could not be complied with, as the representation sought to be disposed of by the court, which is available at page 22 capital B of the contempt petition, is not traceable in the records. Stop. The contempt petition was filed in the year 2020. Notices in the matter were issued as far back as 17/11/2020. However, there is nothing on record to suggest that this representation is not traceable. The respondents are directed to pass specific orders explaining the reasons why the order dated 2/8/2019 has not been complied with, and the order be placed before the court within 2 weeks. Right. Release this matter again on 21st
My lord.
of August.
Representation would be, my lord, as page 21A. That is the correspondent 21A. You know, that would be the reference of the petitioner. That is an exact
21 capital A.
Yes, sir.
22.
21 capital A.
21 capital A.
Yes, sir.
21 capital A. It's the representation.
That is.
The standing counsel, who the Mr. Rai Bodhaku, appearing in the court for the respondents, will apprise the court accordingly, failing which consequential orders may be passed by the court. Mr. B. Rahman for the petition.
Date may be 21st.
21st.
Yes, yes.
In this case, my lord, I am praying on behalf of A. Pupon, my lord. He is suffering from dengue. My lord, matter may come up on next week, man.
Kindly order dated 19/11/2025 and subsequent order matter.
But you have heard the submissions that is indisposed. Are you objecting?
They are taking time, my lord. While they are with my lord.
It is submitted by Mr. Bora that Mr. A. Fukan, the counsel representing the respondents, is indisposed. So Mr. A.M.H.R. Chaudhary, on the other end, refers to the order dated 19/11/25 passed by the court, where 3 weeks' time were granted the respondents 2 and 3 to file their so-called reply. He submits that the respondents have repeatedly prayed for time and the replies have not been filed by the respondents. So, under such circumstances, we permit the respondents further 2 weeks' time to apprise the court as to whether the directions contained in the order. Where is the order? Page number 8.
Page 8 onward. 7 onward.
Direction contained in the order dated 1/11/2022, passed in WPC 5293 of 2020, has not been complied with. In the event, the department may also make alternative arrangements in the event the counsel concerned is found to be not available because of health reasons.
Complex.
Release this matter on 21st.
Complex.
24th. 24th.
Fish note, registry note 2326 Lord. That the advocate entered for respond number 4 and 7. Illegal no ID card or concern notice.
You want to take fresh steps?
But out of this 2, 3, 5 and 6 Lordship, advocate appeared for 2, 3 and 6. Only respond number 5 has not appeared.
Who's respondent 5?
Respondent 5 is the secretary and LR Lordship of Government of Judicial Department.
That the state can appear.
State.
And that was the concernment Lordship told that notice has already been Lordship delivered to.
Who's representing? Who are the respondents represented you are appearing for?
I am appearing for respondent number receipt 6.
6. 1 and 6. There's an amended
There's
cost.
amendment also. And for I am also appearing for Losip. I like to point out to Losip. Losip, can I turn to page 63 of the content petition? What was the direction?
63.
Yes, Losip. At page 62, Losip, para 16, Losip, can turn para 16, page 62. The Secretary to the Government of Assam in the Department of School Education shall place the case of the petitioner before the next meeting of SLC, State Lordship, for compassionate appointment, phrase for her compassionate appointment, considering her eligibility in any grade 3 post, being a master degree holder in Assamese, relaxing her overage at a time of application or compassionate appointment in terms of the clause 16 of the OM dated so and so. The petitioner shall submit a certificate copy of this order along with a copy of this petition, including the annexures thereupon before the Secretary of the Government of Assam in the Department of School Education, providing her address, mobile number, so and so. After this is decision, the state committee for company appointment shall intimate the petitioner regarding her claim for appointment. Accordingly, lawsuit her case was placed before the SLC. We have filed an IA lawsuit, IA 87 of 2026. There we have enact the minutes of the SLC lawsuit meeting. It was placed before the SLC lawsuit.
Where is the, some IA has been filed?
87/2026 lawsuit. Because earlier there was a personal appearance, so we have filed this IA for the lawsuit. They have enact the minutes of the SLC lawsuit, page 19. Lawsuit may kindly turn to page 21. 19 is the first page lawsuit. Annex 3.
21.
Page 21, last para lawsuit. Second last para. May I say moreover the third para from the top lawsuit. Moreover, the Personnel B Department issued OMs dated so and so, wherein it is stated that no cases for appointment on compassionate ground to the family member of the state government employees who died in harness prior to 31/3/2017 shall be entertained by any administrative department of the authority for any reason whatsoever, not to be placed before the DLC SLCs for recommendation of the candidates for appointment on compassionate ground. The cases of employees who died in harness after 31/3/2017 have been taken care of by way of compassionate family pension scheme in lieu of compassionate appointment by OM dated so and so so and so. Further, considering the fact that there is a lapse of considerable time since the date of application, the proposal for appointment in respect of Srimati Ruby Goswami could be understood to have spent its force in light of ratio laid down in the case of State of West Bengal versus Devabrata Tiwari and others passed by the Honorable Supreme Court in civil rule number so and so, but judgment dated 3/3/2023, wherein the Honorable Apex Court has observed that the application for appointment on compassionate ground shall have no redeeming purpose to be considered due to effects of time, as the sense of immediately in the matter of compassionate appointment has been lost, and also taking into consideration the mandate of both OM dated so and so so and so. Under the above circumstances, though the personal department by OM dated so and so at its clause 16 empowered the SLC to grant relaxation of upper age limit, this SLC has decided to regret the petitioner to appoint under the compassionate ground by way of relaxation of upper age limit. Otherwise, there is every possibility of creation of precedents, and there may be chances of future litigations. So it was placed and it was decided lawsuit, and that was the direction of the Honorable Court.
No, Lordship, that is not the direction. I am not going to the merit of the case to the Lordship, because notices are issued in the IA Lordship to be respondent, newly included respondent.
IA is disposed of.
141. 141 in 141. This respondents are included. Here the order dated Lordship 4/20. So only I am for the whether the notice was served to this newly respondents or they are appeared or they have not. Though he is appeared for some respondent, he has not filed the affidavit. In a contempt proceeding, Lordship, he has to file the affidavit before the court. They cannot take the order of the court in their hand, Lordship, from their own hand, Lordship.
So why have you not brought it here? You want to say the SLC has already rejected the case.
Yes.
So therefore the order has been complied with. Why did you not bring it in the contempt petition instead of giving a reference to an IA which has been disposed of?
We'll find a short petition lawsuit. Right.
SLC, Lordship, earlier.
Now, have you seen the order of the SLC?
Lordship, he has Lordship pointed out the paragraph 16, but paragraph 15 is irrelevant, Lordship. In the order, Lordship, paragraph 16. Paragraph 15. Considering the provisions laid down in Office Memorandum noted above, the impending decision of the State Level Committee for Compassionate Appointment, rejecting the case of the petitioner for a compassionate appointment in terms of said office in the memorandum is meeting held on 4/1/21 on the ground of overage and under qualification for the post of assistant is hereby Shetachan quashed. When their decision of SLC Shetachan quashed by the court, how they can again also rejected our claim?
Where is
Earlier, Lordship, my claim was rejected by the SLC, Lordship. I came before the court, Lordship,
challenge the said lordship decision.
So this
So
was
Honorable
again,
Court was and says the decision of the SLC. So directed to place my case for my appointment.
Hmm.
So how they can also again quash the lordship, reject my claim? Once the court rejected their decision, how they can second time they can reject my claim?
where is the order of the court again?
Yes, 62 lordship. Yes,
62.
62. Paragraph 15. That modifying the appeal or any review lordship against this order, how they can reject again my case lordship on the pretext of some notification? These are settled law from the Supreme Court here. That without any modification order, you cannot deny the court's order. You have to complain that order passed by the court.
You bring it on record.
Ultimately, SLC lordship, we have direction to us to place before SLC. We have placed it, and SLC represented by my college lordship. The chief secretary is the chairman of the SLC.
So SLC rejected it
Yes.
on what ground?
If it-
Spent its force
Yes,
in the light of Devobroto.
yes,
Do you bring it on record?
Yes.
This will require examination. Mr.
Notice lordship, the respondent was five, maybe lordship, need to be staffed.
my lord.
Mr. P. Sharma, advice for the writ petitioner.
My lord, when my friend is appeared lordship, I think that other parties are not receiving.
Yes.
Lordship, everybody.
Mr. Chisti appears for respondent number one.
One, my friend, Lordship, the chief secretary by my friend.
No, amended post title one is
Amended.
the secretary,
Amended.
education
Yes,
department.
is it right?
Mr. Chisti appears for respondent number one.
Yes.
Then respondent number six. Then Mr. Who appears for respondent two? The chief secretary.
Chief secretary, my.
I'm a bit. But respondent number two, respondent number three, the commissioner and secretary personnel department, and respondent number seven, deputy secretary personnel department. I
Learned council appears for respondent two, three. Then LR also.
But I have not received the instructions to, but I can appear. But
No, we are directing you to appear.
not, yes.
For
No,
the
in
LR,
fact-
respondent number five
In fact, one aspect. Lordship,
and
kindly
respondent
consider.
number seven.
One-
Mr. Chaliha appears for respondent number four. The learned counsel for the respondents have entered appearance on the request made by the court
Yes.
to represent the respective respondents in view of the pendency of this matter. Contempt case, seeking a direction which has been filed due to non-compliance of the directions contained in the order dated so and so 28/4/2023, passed in WPC number 7175 of 2022. Where Mr. Chisti submits that earlier an IA was filed, being IA number
87.
87 of 2026, where prayer was made for dispensation of personal appearance of respondent number one, where a copy of the order passed by the SLC was also enclosed. It is submitted that this SLC minutes,
Dated
there is a date
31/10/2025.
dated 31/10/2025, had examined the case of the writ petitioner in deference to the order dated so and so, passed in WPC so and so, and upon detailed consideration of the facts and circumstances, concluded that the case of the petitioner not be considered, as it has to be understood, as the application has to be understood, application of the petitioner has to be understood to have spent its force in the light of the ratio laid down by the apex court in the state of West Bengal versus Degobrat Tiwari, which is reported in so and so. So, however, the IA is disposed of by order dated 4/2/2026 without issuing notice. Therefore, we permit Mr. Chisti to bring on record by filing additional pleadings in respect of
Outcome of the
so and so order of the SLC within 2 weeks.
Yes.
With copy being served on the counsel for the petition. Matter will be listed thereafter.
obliging.
26th of August.
Obliging.
26th August.
One of the LR personnel department, they were not party in the petition. In fact, they have been included here, and the honorable court's order was to the secretary education department to place the.
There is an amended course title filed in pursuance to our report.
That, yes, that.
So all of them are the members of state,
They were party,
level
they were member of the
state level
SLC.
committee was the party lot.
The IA copies and the section.
The counsel for petitioner will furnish all the pleadings, the copies of all the pleadings filed to the respective counsel who are representing the respondents today. The copies be served within 2 working days.
Yeah,
All other lots were already sent. He already
Whatever-
did for the IA.
If not already served. Whatever you want, you serve it within 2 working days.
As per the last occasion, respondent of the instruction.
Lordship, we have received the instruction, Lordship, 2 weeks time to file it.
MSN Chaudhary, standing counsel BTC, further reduce the pay for further time. Decrease for next time to complete her instructions and he submits that instructions have been received. Decrease for 2 weeks time to bring it on record by way of an affidavit. MS Gorpujari for UGC. MS B. Bora, behalf of Mr. D. Ukumani, respondent 1, 3, and 5. Let the affidavit be filed and sprayed for within 2 weeks with copies, advance copies being served on the respective counsel, the parties.
Okay.
Mr.
Yes, sir.
S. Ahmed appears with the writ petition.
Apply.
As per last order, they have sought time to file affidavit, 3 weeks, but they have not filed affidavit.
I need some time.
Already 2025 content matter, Lordship.
25 matter.
Lordship.
Respondent counsel, Mr. P.K. Bora, raised for and is granted further 2 weeks time to complete instructions and file affidavit. It is made clear that by the next date, if affidavit is not filed as prayed for, court may proceed to pass consequential orders. Mr. R. Sharma appears for the writ petition.
Let me fix it.
Blessed. Released again on 28th of August.
Apply, Lordship.
Complied with my order of this honorable court has
Order complied with.
Right.
Yes. You serve a copy?
Come next week, Lordship.
No, what next week?
No, because the direction,
You, what is the direction of the court?
page number 63, Lordship.
63.
Paragraph 21, 22. They have filed individual representations. I don't know whether they have.
Individually.
my lord.
Have you considered them individually?
Yes, my lord, individually. Yes, my lord, in regard.
Whether the order has been issued.
Yes, my lord, serial number 3, my lord, person concerned, and this is in regard to my lord Monturam Bons.
Is petitioner number
1.
1, my lord.
1. How many petitioners are here?
29.
Where are the other orders?
My lord, in in respect of the others person also, my lord, we have issued, my lord.
You produce all that
Yes,
day
sir.
after tomorrow.
Yes, yes. Yeah, but
Day after tomorrow, it is submitted that the directions contained in the order dated so and so, passed in WPC so and so, has been complied with. Copy of the order passed by the authorities dated 5/26 is placed before the court and is kept on the case record. It's a part of the case record. Counsel for the petitioner, however, points out to the directions contained in the order dated so and so that the direction was to the court had permitted the petitioners to file individual representations and the department was to consider the cases individually and pass appropriate orders. Counsel for the respondent submits that individual orders have been passed. She would like to place the details thereof on so date, what is 5th of August. Released again on 5th of August.
obliged.
Can you see the official dated 31/7/2026 version?
Lordship, Mr. P. Datta will appear in this matter. Lordship will
Hmm?
take up the matter after some time.
Hmm?
Mr. P. Datta will appear in this matter, Lordship. Lordship may take up the matter after some time.
Affidavit not filed. All right, after some time
Lordship.
at 2 p.m.
Lordship, in respondent number 7, services also not served. Lordship.
We'll take it up at 2 p.m.
Revision notice was issued, my lord, but the indemnity department has not filed any response.
It's a review matter.
My lord, regarding my lord, lordship has directed
You
that
have not taken steps.
they have taken step, my lord.
Office note dated 3007
They have received
reflect no steps have been received by the concerned section.
they have received, my lord.
Office dated 3007-2026 reflects that steps on respondent number 2. Steps for service of notice on respondent 2 has not been received by the concerned section. Stop counsel for the petitioner on the other end submits that steps have already been taken. Stop of registry will verify and make necessary endorsements. And this the
But I
matter
take my step.
again after 1 week. Mr. N. Sharma for the petition. Yes.
My lords, I am appearing for the petitioner in this matter. Notice was issued, my lords. It is a section 11 petition.
AD card is awaited. You are appearing on behalf of all? Brahmaputra board. Are you filing any objections? In deference to the order dated 4/5/2026, steps were undertaken. Stop, although office note dated 8/6/26 reflects that AD card on respondent, a sole respondent is awaited, and MSL Devi, learned CGC, appears today and submits that she represents the sole respondent. Stop, she prays for 3 weeks' time to complete her instructions and file objections, if so advised. Mr.
Varun Sharma, my lords.
Mr. Varun Sharma appears for the petitioner. Virtual mode. Released again after 3 weeks.
My lords, any particular date may be fixed. I am just requesting, my lords.
2nd of September.
Much obliged, man. Second, sir. Much obliged.
Put some time for updated instruction.
There's a clear direction of the Honorable Court, to reinstate the petitioner saying service. Despite that, they are not complying with the order. This is passed in the month of. This is an interim order. No, madam.
Fine.
Final order, madam. Final order. Final. So what is that? What instructions?
Whether any process has been initiated or not.
You
For
want time?
instead, minor.
You want some time for
Minor,
instructions?
Yes.
MSS Sutia, learned counsel representing respondent,
Minor.
sole respondent.
Number 2 minus.
Respondent number 2 prays for and is granted 2 weeks further time to apprise the court as to whether the directions contained in the order dated. There is the order. Order was filed at page 32. Judgment 2/12/2025 passed in WPC 5641 of 2020 has been complied with. Released again after 2 weeks. Both these contempt petitions against the same order. Directed the respondents to place the compliance report. The respondents will place the compliance report within 2 weeks, failing which consequential orders may be passed. Released again after 2 weeks. 24th August.
My lord, in the main case, my lord, I call for 3 affidavit, my lord.
Right.
That affidavit your lordship may take it account for striking of the name of 3 petitioners. They want to strike their names.
You have to file an application.
My lord, I filed in the form of affidavit.
No, not in the form of affidavit, an IA for striking off.
My lord, your lordship, in the main case, it's already on record, my lord.
What?
The affidavit.
We have this affidavit, but you're asking for a prayer.
Just to strike off, my lord.
You are making a prayer before the
My-
court.
my-
So file an appropriate pleading. Affidavit is to bring on record some information. So where is the prayer? In your affidavit, where is the prayer? Show us.
Actually, my lord, in the affidavit, I have made para 2 and 3, my lord.
Is there a prayer in your affidavit?
No prayer, my lord, only
Then?
to strike off.
On what basis are we considering your prayer? Oral submissions.
I understand, my lord. But they sought urgency, my lord.
What is the urgency in striking off the name?
They have some difficulty in their service. Because of the pending of this case, my lord, they are some affected in service. They are normal sector teachers. I think they have no objection. to striking.
This, which petitioners?
My lord, petitioner number 3, 4, and 10. 3, 4, and 10.
You file an IA, will list it on Wednesday.
But they decided. Second.
How can you file an additional affidavit and asking a prayer? There is no prayer on record.
Yes, my lord, that is true, my lord. Only in the matter I stated. My lord.
After 2 months, if somebody comes and says, I did not make a prayer, where is the ground for the court to strike
No.
off their names without a prayer being there? You ask them to file a proper application.
File it, my
Counsel
lord.
for the petitioner submits that petitioner's number
3, 4, and 10.
3, 4, and 10 have filed an additional affidavit expressing their desire not to be a part of the present proceedings and request to strike off their names from the array of the writ petitioners. Stop. The affidavit, however, although expresses the desire of the deponents, there is no specific prayer in the affidavit. Therefore, the counsel for the petitioner is permitted to file proper IA seeking prayers made. Who has filed this IA 187?
My lord, we, the applicants, petitioner,
Praying for?
paying for certain relief, my lord. But in that I am in the meantime, another connected appeal has come up, 20 of August. So we are basically concerned with the main case now.
All right.
The other
So
case
you
is-
filed it on 20 August. The matters be listed on 20 August. Enabling the respondents, enabling the petitioners number
3, 4, and 10.
3, 4, and 10 to file their appropriate IS. Mr. C. Sharma for
NCL instruction.
NCH.
Main matter may be listed for admission. I file on.
The matter be listed on 19th. No, sorry, when is it listed? You said 20,
20 August
20 August
for admission.
for admission.
We have filed an IA lawsuit.
Who is he? Who is the applicant? Who is the respondent of the party?
He's the one of the candidates lawsuit. From government is now easier to be appointed, but his marks is much less than me. That is the
Heard? Yes, any objections here?
My lord, this objection, sorry, this application is filing a wrong, my lord, provision, my lord. It's been filed under order 1, rule 3. It should have been, my lord, order 1, rule 10, my lord. Because order 1, rule 3 says who can be a defendant or the respondent, my lord. It doesn't allow implement of party at any stage of the suit, my lord.
We'll overlook that for the time being. Is there any other objection?
No, no, my lord.
Heard counsel of the party. This is an application seeking treatment of the respondent number 4, the hero of duty Dhaka. It is submitted that the state respondent party number is submitted that the state opposite party the person secured lesser marks than the writ petitioner, and there is a proposal by the respondent, state respondents to confer appointment on him. So, since the petitioner has filed the writ petition seeking a direction from the respondents, so a direction to the respondents to appoint the petitioner, the steps undertaken by the proposed to be undertaken by the has any order been passed? Any order for appointment? Then how do you, where is your apprehension?
So they have filed their affidavit. The affidavit, they stated that department has already appointed in my place is some other else.
The counsel for the petitioner submits that, where is the affidavit? Where is the affidavit?
Principal lordship.
Where? The learned counsel for the petitioner has referred to the additional affidavit date filed on 5th of March 2025 by the respondent number 3, where there is an averment that one hero of duty Decca has been selected for appointment against the roster point number 16 within bracket unreserved, which is under the process in the office of the Director of Higher Education. So the counsel for the petitioner submits that from reliable sources, it is informed that petitioner is informed that the said hero of duty Decca has already been appointed in place of the writ petitioner. So under such circumstances, this IA has been filed seeking impleadment. Hero of duty Decca is as a party respondent in WPC number 1983 of 24 as during the course of the hearing and upon and in view and in while considering the prayers made, adverse orders, considering the prayers made, if certain orders are passed in favor of the writ petitioner, it may adversely affect the said opposite party number 4. Therefore, the IA has been filed seeking his impleadment in the writ petition number so and so. So the counsel representing the respondents 1, 2, and 3 do not oppose or any objections. So, insofar as the opposite party number 4 is concerned, at this stage the court considers it necessary. The court considers it appropriate to allow the prayer made in the IA as there is a specific averment in the affidavit filed by respondent 3 regarding the selection process being undertaken in favor of the opposite party number 4. So the opposite party, upon being arraigned, will get opportunities to file necessary affidavit and contest the case of the writ petition. Therefore, without issuing notice at this stage, the court considers it appropriate to allow the IA. IA accordingly allowed. Sri so-and-so is arraigned as respondent number 4 in the writ petition in WPC 1983. Petitioner will file amended post title within 1 week from today. In WPC so-and-so, you write view of the order passed today in IA number so-and-so. Hero of duty Decca is arraigned as respondent number 4. present proceedings, petitioner will file amended post title within 1 week. Oblige that.
May I please the lordship?
Hmm.
We file this I for under order rule 6, order 6, rule 17. Read it section 151 CPC for amendment of a technical error. Kindly say paragraph 2. Then the address of the respondent number 5 was
You
wrongly.
are furnished now. You are furnished.
We have taken steps of respondent 5.
5.
But it was a return answer. No such person in the address.
Now you take fresh steps on the correct address.
On the correct address. Yeah. The
Counsel for the applicant is permitted 2 weeks time to take fresh steps.
on the new address.
The correct address
So, I think-
of respondent number 5.
Sir, the amendment in the post title and the synopsis.
Correct address is this, respondent 5.
This is what she rub. Paragraph 5 will also Rabjit Rao, resident of Pancharavi Lakshmi Charan Road near Yukana Masjid.
Alright.
PO.
This IA has been filed seeking correction of the address, respondent number 5. The address which was reflected in the writ petition accompanying the petition with the PPC numbers is, so far as respondent number 5 is concerned, is you are seeking implement or
Amendment of the address of
but
the.
in the writ petition, there is only 4 respondents. Subsequently, you file for implement.
No, sir, there are 5. There was 5.
Okay, 5 respondents.
5 respondents. Sir.
The respondent, the address of respondent 5 reflected in the course list, reflected in the course title of the writ petition. Of the correct address of council is the writ petitioner has procured the correct address and therefore seeks to make the necessary corrections. And accordingly, prayer has been made with the IA number 480 of 2026. The correct address is reflected. The IA, so far as respondent 5 is as under page number 3, respondent 5 is expected. There are anyone for the respondents? Any objections?
No.
Council appearing for the respondents do not object to the prayer made. Accordingly, this IA stands allowed. The petitioner is permitted to file amended post title reflecting the correct address of respondent number 5 within 1 week before the registry. So, IA accordingly stands allowed. Disposed of the writ petition. You write in your IA enforcement order passed today. The petitioner is permitted to file amended title to the registry reflecting the correct address of respondent number 5, which is mentioned in the IA as under the extra code. The registry will list this matter after the amended post title is filed with the petitioner. After 1 week thereafter.
In this case, I am praying for impeachment of the finance department as respondent number 6.
Any objections, respondent? What is your prayer? Revision. You are praying for revision.
In a writ petition,
Yes.
Lordship, I'm praying for sitting aside of the Lordship. On
There's some
order.
disparity in the
In the-
petitioners case. The assistant teachers, Lordship, they're claiming that they have similarly situated teachers have been given.
So finance is a necessary party.
Yes, Lordship, we were required to assist the court. We had assisted the court, but in the meantime, the honorable court has directed that our affidavit might be required.
Is there a direction?
No direction.
On 4th of June, Lordship, the finance has placed some instruction on them. They have recorded.
Yes, we were assisting the court.
That's why, Lordship, I'm praying for
Some
statements so that they can file affidavit.
Lordship, but in the affidavit, in the instruction, it is clearly stated that the clarification has to come from the education department, but there are some instructions as to.
Third counsel of the parties is the writ petitioner before this court has filed an application, has filed a writ petition for correction of their fee in terms of the fitment table. Which has not been correctly applied by the respondent authorities. In the last order dated 4/6/2026, where the finance department was requested by the court to assist the court, the submissions of the council to the finance, the court recorded that there is a discrepancy in the amount ultimately drawn by similarly situated graduate teachers, which is higher than the petitioner who was placed in a different fitment table. So, liberty was granted to the elementary education department to file their affidavit in that respect. So, there are the counsel for the petitioner. In view of this order, has filed this IA seeking implement of the finance department. It is submitted that the finance is a necessary party and not to have been included as a respondent, not to have been arrayed as a respondent. Writ petition number 7. However, considering the fact that ultimately the views of the finance will be necessary to decide on the question of the applicability of the appropriate fitment table, the application is filed seeking implement of the finance department as a party respondent in WPC number 7. So, the respondents do not object to the prayer made. Accordingly, this IA stands allowed. Finance, what is this? Commissioner and Secretary.
Commissioner and Secretary Finance Department.
Commissioner and Secretary, Department of Finance, Government of Assam is arrayed as party respondent. 6 in WPC number 2648 of 2024. Petition will file amended post title within 1 week. Thereafter, in 1 week from today. So IA accordingly stands allowed disposed in the WPC right in view of the order passed today in IA number so and so. Commissioner and Secretary, Government of Assam, Department of Finance is arrayed as a party respondent. 6. So Mr. H. Aliha is present in court. Accepts notice. On behalf of respondent 5, he is permitted 3 weeks' time to complete his instruction and file necessary affidavit. Therefore, this on finance department be waived, however, extra copies be furnished to the standing council within 3 working days. Petitioner will file amended post title WPC number so and so. Relist after 3 weeks. After 3
In the
weeks,
meantime, education department can also file
the elementary education department will also file their affidavit as permitted by the earlier order.
But before my learned senior starts, this matter pertains to admission of a child into a college, into school, following the mandate given in the Right to Education Act. They filed an IA for vacation of the interim order. The interim order was to allow the student to continue with the school. This is the only interim order. But what I respectfully submit, I will file a reply to the IML in writing, and affidavit in opposition they have filed. We would like to file a reply to that also. And let me grant us some time.
We are yet to issue notice in the IA.
My lord,
My lord, we have filed the IA on 22/7/26.
Yes.
They have received the copy on that day itself. Now, my lord, here is an order, my lord. If I
We are yet to issue notice in the IA.
yes,
It's
my
come
lord.
for the first time.
Yes,
Where is the order you want vacation?
yes, my lord. My lord, we kindly come to page 28.
28.
This has been the order, the operative portions, my lord, page 30, my lord. And it's an admitted fact that the father have preferred this writ petition for a minor of class 9, and a demand notice was given with regard to outstanding dues. And the last paragraph of page 30, my lord, it's contained in the period that the aforesaid amount which has been shown to be outstanding dues have already been waived pursuant to the order of the District Commissioner, Kamrup Metro and Assam State Commission for Protection of Child Rights. That order I don't see, my lord, from the records. So and so learned counsel submits that debarring the petition for attending school solely on the ground of non-payment of fees, which has already been waived, is it clear violation of right guaranteed under 21A of the Constitution of India. This 21A provides from 6 to 14 age, not above 14 age, 14 years of age. Now, notice has been issued, my lord. If I read the last paragraph of page 31, my lord, considering that the petitioner appears to have been debarred from attending school solely on the account of non-payment of outstanding school fees and having regard to the academic interest of educational career of the minor student, it is directed that respondent number 3 and 4, the authorities of the State Bank Officers Association Public School shall provisionally permit the petitioner to attend classes and continue his studies until further order of this court. What I am on, my lord, Right to Education Act, my lord, I have annexed it, my lord, will kindly come to the Right to Education Act that I have annexed, page 50. My lord, 21A has been introduced, and in 21A, it speaks in volume. It is applicable to 6 to 14. He is above 14. Now, this Right to Information Act, my lord, yes, page 50. Kindly come to page 51, and this is, my lord, F. Kindly see F. Elementary education means the education from 1st class to 8th class. Am I clear? So, from 1st to 8th, under the Right to Education Act, it is, my lord, free education.
That's all right. We'll go into all this.
Yes,
But
yes.
why the fees was not paid?
my lord, what fees under the Right to Education Act, as my learned senior has rightly pointed out, it is up to 14 years. They have, by the impugn order, they have charged me for the period which has been by dint of application of law, my lord, they cannot charge.
May I submit, my lord?
My lord, this is the point.
This is not the truth. This is the half truth. From class 1, the minor have taken admission in 2018. Class 1 to class 4 duly paid all the fees. 5, 6, they have not paid the fees.
You are saying that from 6 to 14 years, it is free education.
My lord.
What is the meaning of a school year?
School includes, my lord, may I take your lordship?
School established or owned by the appropriate government or local authority.
Yes.
Aided school.
It's
School
not aided
belonging
school.
to specified, unaided school. It is not by local authority or.
My lord, I'll come with appropriate reply, my lord.
Right.
May I point out, my lord, at this point of time, my lord, whatever I have learned from my experience, my lord, come with clean hands, you get an order from the court, not with half truths. Class
These
class-
are
my lord,
disputed,
may I
these are
submit, my
disputed questions. My lord.
My
Sorry.
lord, it's not disputed, it's on record, we have annexed the document. Till class 4 already paid, my lord, everything, no dispute. Class 5, 6, he has not paid.
There is
My lord, he has not paid. Now there is no RTI, this right to education.
Till class 4, he did not come in contact with Mr. Chomwa. So he did
That's
not
what it
realize.
is. That is the
So
answer.
Mr. Chomwa advised him, perhaps he don't
My
know.
lord.
Actually, what happened, my lord? The father suffered a serious illness because of that, my lord.
All right, we'll let us issue notice, let them file their
My lord,
response.
may I pray with regard to one prayer, my lord? That is my very reasonable prayer. Till the next date, listed before this honorable court, that interim order shall continue.
My lord,
Not till further orders.
my senior friend is asking an order from this court, debarring a minor from going to the
No,
school.
law is law.
This is
Nothing is
uncalled
there.
for, my lord. This is uncalled for from a senior counsel, Mr. Bhuya.
But
This is uncalled for.
You have knowingly admitted a child into a school, knowingly that they'll have to pay a fee.
My lord, he was reading there since class 1. Suddenly, his father fallen sick, seriously
That
become
is a different issue.
40%
That is a
visible.
different issue.
Then he claimed the benefit of this act. Where is the wrong in it, my lord? There is no wrong in my
That we'll
estimation.
examine it.
Yeah.
If this is the interpretation given,
Definitely, my lord, come up with all the.
I'll be very happy to pass an order that
Yes,
all
madam.
children between this in any school are to be
My
given
lord,
free.
25% of the total seat of a preliminary school has to be given benefit of right to education.
That is a different issue. That has a different
Now,
criteria.
Lordship the question has fallen from your Lordship whether this school will be covered within the meaning of school or not.
Right.
That I'll clarify.
And apart from class, till class 9, my lord, not after that. 8, not
Ah,
9 and 10.
I'm not asking for class 9. I am saying.
No fees, my lord.
I am saying that or
No
we are.
fees. No admission fees. No tuition fees.
Well, let him submit, then I'll.
Right. Third, Mr. A.K. Bhuya, London City Council, assisted by Mr. So, appearing with the applicants. Appearing in IA number 2519, the applicant. This IA has been filed seeking vacation modification of the order dated
15/6. At least 30. 15/6/26.
15/6/2026. Which was past ex party, the applicants. The IA has been filed seeking vacation modification of the order dated so and so. Let this issue returnable. When can you file your objections?
At least 3 weeks time.
Hmm.
Well,
Or at
some
26th
preoccupation.
26th of August,
Yes,
Yeah.
yes,
26th,
correctly.
by which time the respondents will file their objections, if any. Yes,
My lord, in the main case, my lord, I am appealing for the respondent number 2, this is the general manager of the bank. We have no role into this, so today during the course of the day, we will file a appropriate.
appropriate application for what? Striking.
For
order. Matter be listed again on 26th August, by which time the respondents will complete their pleadings, exchange their pleadings and file necessary affidavit. You file it, then we'll pass an order if you want.
My present mail, I am appealing for the respondent.
Respondent number
2, you know.
is represented by Mr.
K. Das.
K. Das.
Problem.
You are appearing in the IA also.
That copy is not sharp to me.
To the petitioner.
Extra copies we furnished
Yes.
on all the respondents.
Well, this interim order till the next order.
Interim order passed early will continue till 26th.
Deeply obliged.
I can see on last occasion, Lordship directed me to get the instruction whether it was sent to the finance department or not proceed. The secretary has already sent the proposal to the finance department on 30/7/2026. They sought some queries that was met on 1/8 Lordship. It was sent again on 1/8/2026 Lordship for the finance department.
Mr. SMT Chisti submits that in reference to the directions contained in the order dated 28/7/2026. The proposal was sent to the finance department, and upon certain queries being raised by the finance department, the same has also been met and furnished on
1/8/2026.
2026. The matter is presently before the finance department. Mr. A. Chaliha,
But they are not parties. Lordship may direct them.
counsel representing the finance department, they letters the court the status of the proposal stated to be forwarded by the secondary education.
Lordship, yes.
Yes, ma'am.
Secondary education department. So Mr. Chalia is requested. We'll furnish the instructions only in the request of the court, at the request of the court, as the finance department is not arrayed as a party. Mr. Abedin appears for the petition. Released on 21st
Yes.
August.
Seven 67 Lordship, the director has sought proposal from the inspector of school. The inspector of school Lordship has sent the proposal, but that 67, it was same. It's same.
Same.
Yes. 67 is same.
Same. Released again on. What date?
21st.
What date will be fixed? 21st.
21st. Both are together.
It can be tagged as with.
Both the matters be listed together.
Yes.
21st.
In 68 Lordship, the director has sought a proposal from the inspector of school for a payment of area salary. The proposal was sent Lordship, but found some discrepancy. So it was again sent to the inspector. They are rectifying it now. Lordship, as soon as we receive from the inspector of school, it will be sent to the government.
Last order, kind of.
He has placed the instructions.
Yes.
Mr. J. Law School Counsel Petitioner. Mr. SMT Chisti, Standing Counsel appearing for the respondents. Respondent number 1 submits 1 and 3.
1 and 3.
That the director had sought for the proposal for the area salary from the inspector of school Hailakandi. The said proposal, although received, upon examination, there were certain discrepancies noticed. Therefore, a revised proposal was called for by rectifying all the wrong entries. This communication was sent to the inspector of schools on 1/8/2026. The counsel for the respondent 1 and 3 submits that the matter be deferred again 21st.
Yes.
Accordingly, release this matter on 21st. We'll give you 2-3 days more time, 26th of August.
Yes, obliged.
By which date the respondent counsel will apprise the court with regard to the proposal being sought to be received from the inspector of school. Revised proposal for area salary sought to be received from the inspector of schools. Mr. A. Chalia appears for the respondent number 2.
Obliged.
May I please the Lordship, my lord, the applicant before your Lordship is the writ petitioner number 17 in the writ proceeding, my lord. My lord, she seeks to withdraw from the writ petition, my lord.
Who's for the respondent? Any objections?
I'm appearing for the principal secretary.
NC Hills. Who's for the NC Hills?
I'm appearing for the principal.
You are appearing for all.
No, for the principal secretary.
Principal secretary.
For the education, there's another.
Who's for the NC Hills?
I am for the respondent.
Respondent number 1.
C. Sharma.
Respondent number 1. Any objection to the IA that is being filed for striking of the name of the writ petitioner? This IA has been filed by the applicant seeking an order for striking of her name from the array of the writ petitioners. Stop in the accompanying writ petition 4731 of 2024. The petitioner's name was reflected at serial number petitioner number 17.
Yes.
Stop. Presently, the petitioner does not wish to press the writ petition any further. Therefore, the application has been filed seeking deletion of her name from the array of the writ petitioners. Mr. B. Talukdar appears for respondent 1. Mr. Mr. D. So-and-so appears for the NC Hills Council. The respondents do not offer any objections. The prayers made. Accordingly, I stands allowed. The name of the applicant so-and-so. Still night.
Yes, madam. Still night Sushian.
So-and-so be deleted from the array of the writ petitioners. You are otherwise appearing for petitioners.
Yes, my lord.
So, stop. Mr. D.P. Bora, who otherwise appears for the writ petitioners in WPC number 731 will file amended post title within a period of 1 week from registry. I accordingly stands allowed disposed of the accompanying writ petition right in view of the order dated so-and-so, passed in WPC so-and-so, IA number so-and-so, the name of the applicant so-and-so, which was arrayed as respondent, which was petitioner number 17 in WPC so-and-so, sought deletion of a name by filing the IA number so-and-so, which was allowed by order dated so-and-so. So, writ petitioner, counsel for writ petitioner will file amended post title to the registry. Matter be listed thereafter.
My lord, the other way, the writ petition is fixed on 28, my lord. Writ petition.
20.
20, my lord.
Matter be listed on 20th as it is submitted that the material writ petition was directed to be listed earlier, subject to filing the amended post title before the registry as directed.
Obliged, my lord.
Lordship, kindly Madam will be adjourned for the day, Lordship.
The request is made on behalf of the counsel petitioner. Have the matter adjourned for the day. Prayer made is allowed. Relist after 1 week. Yes.
Obliged.
Mr. P. Sharma and Ms.
S. Sharma on behalf of Mr. P. Sharma.
S. Sharma appears for the respondents.
Lordship.
Elementary education and
Respondent number 5, Lordship.
accountant general.
Accountant.
Accountant general, respectively.
There is pending since 2023, no affidavit has been filed. And Lordship, on the basis of a legal opinion of the Advocate General, Lordship, the respondent number 4 was appointed as the regular expert. Although there was no any direction from the division. It was inspector of school who was holding this.
In spite of repeated opportunities being granted, it is seen that the respondents have failed to file their counter affidavit. The matter therefore be listed for admission hearing on 25th of August.
Lordship, I make a submission. However, there was some development. The petitioner had informed the respondent that he is withdrawing the case. This is what was the instructions because he is retiring on 31st of August this year.
How has he informed?
orally, I think there was an agreement which is probably not put forward. We'll have to take instructions on that. What has happened? to
No, I
that?
am retiring on 30th September, not August.
This is what I was given. The instruction is this.
We are fixing it on 25th. You get your instructions.
Hey, this is Sonachi. Noted the respondent side is yet to file their counter essay. The last. They have
What
not
is your
filed it.
prayer? Why have you filed this voluminous writ petition? What is your prayer?
Directing the pension limit. For pensionary benefit challenge.
Pensionary benefit.
Yes, sir. Along with the arrears challenge.
Respondents?
My lord, kindly peruse page 21, my lord, pair person. Whether this petition is maintainable, my lord. Whether this petition is maintainable, my lord. Kindly peruse page 21, my lord, pair. Directing the official respondent authorities cancel, withdraw, recall, rescind, forbear from giving effect the order dated 23/11/2019. In annex of my lord, there is no such document, my lord, 23/11/2019, my lord. Subsequently, my lord, and passing the said order dated 23/11/2009. The prayer B. My lord, whatever, my lord, they are appointed in 2009, my lord. Subsequently,
No, do you want to file your affidavit or not?
my lord,
Is that order withdrawn?
no, my lord,
It is still there.
still there, my lord. They are retired, my lord.
They're retired. They're asking for pension,
Old pension scheme, my lord.
whole pension scheme.
They are retired on
So
2021.
if you want to file an affidavit,
My
we'll
lord.
give you time. If you don't, then we'll fix it for hearing.
We'll file, my lord.
The heard counsel,
M. Kakoti, Your Lordship.
Huh?
M. Kakoti.
M.
Kakoti.
Kakoti appears for the writ petition. And Mr. B. Talukdar appears for the elementary education. Representing respondents 1, 4, 1, 4, 5 and 6. And Mr. B. Pegu appears for respondent number 3. And Mr. Chaliha appears for respondent number 2. The respondents are permitted 3 weeks time to complete their instructions and file affidavit if so advised. Release this matter again 28th August.
Obliged.
Please, your lordship. Regarding payment of arrears salary by order dated 17/2/2025. The instruction was.
Yes, instructions.
Lordship, I have not received. Lordship, I pray for another 2 weeks of time, Lordship. I'll obtain.
Mr. T. Das for the petitioner, MS N. M. Sharma.
Lordship.
Standing counsel,
Secondary
education, renews the prayer for further time. She prays for 2 weeks time. Considering the issues involved, we permit the standing counsel to complete her instructions and file necessary affidavit within 2 weeks. Released again on 26th of August.
Obliged.
Here, your lordship, in 2 cases, they have filed their affidavit. Rest of the cases, 3 cases, they have not filed it. These affidavit covers the all, then your lordship can.
What is your prayer here?
Prayer, your lordship, the issue is whether your lordship, my cash promotion will be effective from the date of eligibility or from the date when it was given. They have given it from the date of consideration, your lordship, and we are claiming it from the date of eligibility as per the AICT rules. That's the issue.
Yes.
But this two affidavit will cover all the cases. Maternity leave for
It is submitted by the counsel for the petitioner, Mr. Abu Senior Advocate, assisted by Mr. P. Khatonier. That the respondents have filed their affidavits in WPC number
1769.
1769 of 25 and
Number
177.
1772 of 2025. So it's submitted by the Standing Council Education, Mr. S. Das, that these two affidavits will cover all the writ petitions and therefore no further affidavit is called. So that view of the matter. Are you filing rejoinder?
No, Your Lordship, I will not.
The counsel for the petitioner also submits that he would not like to file any rejoinder. Accordingly, matters be listed for
27th
27th.
August.
All right, is agreed to 27th of August.
Deeply.
Net basis selection. Malad, here, Malad, we have completed our PhD degree in 2013, Malad. And thereafter, our services were, Malad, provincialized in 2014. After 6 years, Malad, they want to dispute our degree, stating that I have not completed within 2 years. Malad, 2 years duration for completion PhD come in 2014. And there is a specific clause in the clause 14 in the subsequent notification that those degree obtained prior to the 2014 notification, 2 years duration does not come. Earlier, the duration was reasonable time. So, therefore, and pursuant to order of 15-9,
Readings are exchanged.
they have not agreed with operation is granted.
I'm seeking some time to file affidavit.
What, how much time?
The instruction is not received. I think 3 weeks time, I'll find.
Mr. P.K. Das, APS for the petitioner, Mr. S. Das, Standing Council for the higher education, submits that further time be granted to complete the pleading, complete the instructions and file necessary pleadings. He prays for 3 weeks time. Release this matter again on 28th of
It is
August,
the first week of September.
first week of September,
Month.
2nd of September.
Month. Look, I am protected by interim order 15-9, that may be continued.
Interim order, if any, passed earlier, will continue to the next legal case.
But all the cases, the same order will do. Deeply obliged.
My lord, I was put under suspension, my lord. Long break, my lord, and thereafter no review, no charge memo has been up to me, my lord. Still I am in under suspension, my lord.
Yes. Any instructions here?
Long period.
Can we get
Five Lordship.
Many times has been taken up, my lord. 2024 case, my lord.
Have you received your subsistence allowance?
That was received, my lord, but from 2024, my suspension is continuing.
This is automatically invalid
Invalid, my lord.
in view of the notification.
My lord.
Where is the notification?
I have not annexed the notifications, my lord. So within 90 days, my lord, review is necessary, my lord. So far, my inspection,
You are suspended by which order?
I have annexed, my lord. That is at page number 31. Deemed to be suspended, my lord, because I was arrested, my lord. 31 page number, my lord. Annex of 4.
POCSO matter.
My lord, yes.
You are working as what? Assistant teacher.
Yes, my lord.
What is the status of the criminal case?
That is under trial, my lord.
Under trial.
And evidence of the victims and all other has been taken up, only the investigating officer.
There is no departmental proceeding initiated.
No.
No department revision, no review, nothing.
It is against the allegation is made by a student. Must be.
By the
Also,
parent. Yes, madam. By the parents of the. Yes, madam.
get your instructions here. What steps have been taken? The respondents will obtain instructions with regard to the status of any proceedings that may have been initiated against the writ petition, departmental proceedings, or any review undertaken by competent authority. Let these instructions be placed before the court by the next date, failing which the court may direct appearance of personal appearance, says of the concerned respondent officers. Released on 28th of August.
Not file their affidavit.
Lordship, I have received the detailed report. Lordship, I will file affidavit. Lordship, 3 weeks of time may be granted.
Yeah, 2 weeks.
2 weeks.
You have received instructions, you like it. Mr. Says what about when it's in the assisted by Mr. D. Void. Appears for the petition. Instructions have been received. She is permitted 2 weeks time to file an affidavit. Release this matter immediately after 2 weeks.
Diplo. Please, Your Lordship. The matter will be kindly taken up at 2 years. Seniors and banks.
Any affidavit filed?
No, Your Lordship.
Yes, Mr. Chisti. Affidavit not filed.
No, Lordship.
First wife and second wife. The respondent counsel is permitted 2 weeks further time to complete instructions and file affidavit if so advised. The instructions must indicate what steps have been taken by the respondent for release of family pension, compassionate family pension, the widows of the writ petition, released again after 2 weeks.
Objection.
Similar order. Already quoted one bench has decided.
Yes.
Yes.
Similar direction we will give.
What is it? What is the direction you are seeking?
Present petitioners documents will be verified, and if they are eligible, they may be.
What is your grievance?
Grievance, Lordship, we have applied, Lordship, advertisement dated 8/1/2025, Lordship, for
Advertisement for what?
assistant teacher.
For lower
assistant
primary.
teacher.
Yes.
What is NIOS, UDICE?
I am appearing for NIOS lordship. NIOS also only giving the degree lordship. All verifications should be done by the head of the institution.
Third, counsel for parties disposed.
Right.
May please, Your Worship. Worship, notice was issued on interim prayer meeting. Keeping 7 posts vacant for the PWD candidates. Instructions?
My lord, I have not received. I need some time, my lord. On Friday, my lord.
Friday.
My lord, I'll try.
All right. Friday. The request made by Mr. T.K. Brower at the state paper to be listed on 7th. Friday. Yes, 7th. Well, released on 7th. Mr. B.M. Deka, IBS for the late petition. Much obliged.
Obliged.
Lordship, in this matter, I have received the instruction today only, Lordship, today morning. I will file it, Lordship. In 2 weeks of time. I will file that.
Yes, Mr. Sharma. Mr. S. Sharma, IPS for the petition. And Ms. N.M. Sharma, who is standing counsel. The secondary education who submits the instructions have been received. She would like to file an affidavit. Standing counsel is permitted 2 weeks for the time to file the affidavit. Released again on 28th. Yes.
I have received the instruction, my lord. Since, my lord, the petitioner is a student of Nalbari Law College, though it was not affiliated during the relevant period, the course completion certificate will be issued by the college concerned. Only for examination purpose, that examination center was fixed at University Law College, which is a department.
Although if it is not affiliated, then how can they issue the certificate?
That course completion certificate.
Certificate is
It is not pass certificate. Pass certificate has already been issued. That is in page 15. Mark sheet, pass certificate already issued. The petitioner requires a course completion certificate as well as the attendance of attendance percentage, as well as whether it is in day shift or evening shift. These information, my lord, it will be provided by the Nalbari Law College.
Who is asking for this? Bar Council?
Yes.
Why? There is a certificate already.
But some other document has been submitted.
What is the document you require?
Certificate of the principal of the law college has executed the study of law attested correct.
You want a certificate from the principal. But in the face of the certificate issued by the Gauhati University, why are you insisting for this? What about the final certificate?
Final certificate will be issued, my lord. But now this provisional certificate, normally it is accepted by the Bar Council.
Bar Council is insisting for the certificate from the concerned college in spite of having the provisional certificate issued by the Gauhati University.
This is required under what provision? It's rule. 12.
Possibly it is under 2008 rules. That 65%, 70% attendance. But it is prior to 2008. He has petitioner completed in 1990.
Apart from this, since certificate was issued, presumably, the attendance that what was required, he attended the classes, otherwise he cannot appear in the examination.
Which rule are you referring to? Well, Rule 12 is election of chairman and vice chairman. Your instructions, you should be able to point out properly. So this is for the end semester. You're referring to the end semester test.
At that time, there was no semester system. 1990. And even there is a legal education sector,
Legal Education Act. The middle portion of the book.
Please help yourself.
Well, regarding end semester test.
What we asked it. This is not applicable.
It is prior to 2008.
Yes. Not applicable. Get your proper instructions. Mr. Counsel. We'll give you 1 week's time to complete your instructions. So B. Chaudhary for the petitioner, Mr. P.J. Fugan for the Gauhati University, Mr. V. Chetty enters appearance on behalf of the Bar Council, Assam, Nagaland. Mr. Chetri is permitted 1 week's time to apprise the court the rules, which the certificate from the college principal of the law college, which under from which the petitioner undertook his classes, as also the attendance in respect of the writ petition required as admission for LLB course in Nalbari Law College in the year 1987. And he completed the course in 1990. Stop. The Gauhati University has also issued a provisional certificate. That effect. Notwithstanding that, the respondent one existing of these documents, grant of license practice to the writ petition. The matter be listed again after 1 week. On 12th? On 12th, by which day the respondent will complete their instructions. Released on 12th.
Most of us. But in this case, my senior was supposed to appear by the court, but because of his health, he was gone to Calcutta, my lord. My lord, petitioner is the block elementary education officer. First arrested in connection with the anti-corruption case. Thereafter, he was placed under suspension on top of
Will issue notice, eh?
He has already been started.
Huh?
DP has already started.
I'll tell you, starting issue notice. Returnable 3 weeks. Still PK Bora, standing.
All the respondents.
They have to all the respondents. If one notices away, extra copy. Is that interim prayer? The petitioner has an interim prayer, therefore issue notice of the interim prayer. Returnable on 26th of August.
One problem is that my lord, next date is fixed on 5th, my lord, and on that date it was rejected. Some second enter
5th of what?
5th of this month.
So why have you come today?
No, my lord, we have filed earlier. My
You
lord.
filed earlier, the matter was deferred on your request.
Yes, my lord. On that day, my lord, because my senior was supposed to.
Can we help?
No, my lord, if my lord, a petitioner cross-examine the entire matter will, my lord.
No.
The purpose will.
Released on 24th
August. My lord.
Prayer for interim to be considered on the next returnable date.
Cross-examine, my lord. The entire defense will be disclosed, my lord.
Have you filed has the charge sheet been filed?
No, my lord. Charge
Then-
and my lord, kindly one.
Has the charge sheet been filed?
No, my lord. Charge.
No. Then
And another.
how do you say that the charges are identical?
Charges, my lord.
Charge sheet is not filed.
Charge sheet not filed, but one thing, my lord, in Shoko's notice, kindly see the list of witness, my lord. The complainant is key witness, my lord, and he has been,
You're not understanding the,
Yes.
what you are praying for is that during the pendency of the criminal case, the departmental proceedings should be suspended.
Yes, ma'am.
Is that your prayer?
Yes, ma'am.
Now for that, you'll have to satisfy the court that the charges are identical.
It's correct, my lord.
Then in a matter where there is,
In a
where the charge sheet has not been filed, how do you raise this comparison?
In a similar situation, my lord, this another two court state the process, I have copy, my lord.
Give us a copy.
That case also, my lord, was identical case, my lord.
I don't consider myself to be bound by this order. This is contrary to the views of the Supreme Court. You satisfy us that the charges are identical. It is your submission. Is there anything to say that the criminal matter and the proceedings, same witnesses, same charges, only the complaint?
Is the key. Everything depends on.
But the charge sheet is not filed. It is not filed. You make out a case. Not like that. You make out a case, we give you stay until further orders. Why till next date? Make out a case. Your apprehension is the charges are identical. On what basis are you saying it? You point out to the judgments referred to there in this order by the Supreme Court and tell us that it's an identical case.
Statement of allegation.
Mr. Counsel, there are judgments of the apex court referred here. Tell us that on the facts which were before the apex court and the facts in this matter are similar. We'll accept your submission. You know that it is not similar, otherwise you have relied on the Supreme Court judgment instead of an interim order.
Statement of defendant with the so-called notice filer has been.
All right, we're giving you 2 weeks, returnable on 21st August, not beyond that. Interim also on the said returnable date, 21st August. You make out a case, Mr. Counsel. Make out a case. Yes.
Obliged. In this case, we have received some instruction and we have been directed from department to move in one IA for vacation of the stay order. Maybe granted.
Where is your affidavit?
Lordship for affidavit and IA against simultaneously will file Lordship.
Huh?
I will file the affidavit along with the IA Lordship. At least within 10 days Lordship.
What is the interim order?
The departmental proceeding could not be initiated.
Heard counsel for parties. State council submits that they would like to file. They have received instructions to file their counter affidavit as also an IA seeking vacation of the order, interim order dated 3/12/25. Please for 10 days time. Prayer is not objected to this matter again after 10 days. On date to be fixed by the registry.
May please your lordship. Lordship, the petitioner has engaged another advocate as the learned counselor Al-Usami has been appointed as a special public prosecutor of the special judge.
They submitted that the council is representing the petitioner, Mr. Al-Usami, no longer has returned the brief due of his engagement as a special public prosecutor, the government of the South. So, the petition is permitted for which time to make alternative arrangements Have you filed the application before the registry?
No, Lordship. No.
Council for the erstwhile council will take steps to file an proper application before the registry. Release this matter after 4 weeks.
My lord, we engage senior counsel, Mr. Vitil, as for arguments. Kindly, we engage senior counsel, Mr. Vitil, kindly list it next week.
The pleadings are exchanged.
And we have already filed our affidavit, my lord, on 17/7/26. That's one number 5.
Prayer is made on behalf of the petitioner that the matter be taken up after a week.
My lord,
No objection is raised by the respondents. Release this matter after.
kindly put in interim order, my lord.
Interim order passed early will continue.
Okay.
Made. There are two cases, lordship. In item number 62, we have filed our affidavit, lordship. And in 63 also there is a direction to file an affidavit. In 63, lordship, that so-called notice has been challenged. But the proceeding was initiated. So 63, so-called notice has been challenged, lordship. I prefer 2 weeks time to file affidavit.
Lord, they have actually, what had happened, Lord? There was a criminal case. Actually, petitioner is a block development officer, block elementary education officer. Lord, one lady teacher, she committed suicide. Now, reportedly, my lord, she left behind a suicide note where she alleged that she was put to harassment by the petitioner as a block elementary education officer. Based on that, my lord, there was a criminal case. He was arrested, then enlarged on bail. Simultaneously, my lord, he was suspended also. Now, my lord, they have initiated a disciplinary proceeding. My lord, my humble submission is, what is the misconduct I have committed? If your lordship should kindly come to the show cause notice at item number 63, my lord. Please come to page 24. How can this proceeding be permitted to continue, my lord? Question. Sorry, page 21. Oh. Page 21. While you were serving as block elementary education officer Bihali.
This is in WPC
171.
17.
Item 63. In other case, I have challenged the suspension.
Page 21.
Yes.
Yes.
While you were serving as block elementary education officer Bihali, you were arrested and forwarded to the judicial custody on 7/7/25 by Bihali Police Station case number so and so. As per the report of the police in charge, Bihali Police Station, the complainant Sri Deepak Upadhyay, son of so and so, who was serving as headmistress of Lohari so and so, Lohairam Majolia Vidyalaya, committed suicide by hanging herself in her residence at around 4 a.m. on 6th of July 25. A suicide note recovered from this scene has revealed that deceased took this extreme step due to persistent mental harassment caused by you. Your act has lowered the credibility of the government and it amounts to gross misconduct. It is unbecoming on the part of the responsible government servant. Therefore, you are highly similar. It's a mere allegation in a criminal case. Now, you can very well visualize what will happen to this criminal case. Nothing is going to happen. Now, if I am not convicted in the criminal case, where is the question of proceeding against me on the same set of allegation? Had the charge been something else, something to do with my conduct as unbecoming government servant?
What is the status of the criminal
Nothing,
matter?
my lord. After giving this show cause notice, neither inquiry officer has been appointed.
No, lordship. I have an instruction, lordship.
I have a instructional lordship. The inquiry committee has already been constituted.
When? Where have you intimated to us?
That
No, my lord, my humble submission is, since the criminal case and departmental proceeding are grounded on the same set of facts, following the ratio in Paul Anthony Millard, the DP should be state Millard, and I should be reinstated.
What is the status of the criminal?
That's why Millard. In criminal case, is charge sheet. A charge sheet has been filed, but nothing has happened. Nothing, it has not progressed. Well, that is not the purpose of suspension, Millard, that it will continue for indefinite time. And I was suspended on Millard.
You have submitted your reply
To
the show cause.
Yes. Yes. Denying the allegation at page 24. Now, my humble submission is, Millard, where is the occasion to initiate a DP? Well, end of the day, it must be an informed action, Millard. Merely because a show cause notice has been issued, government advocate stands up and objects. That is not the issue. Issue is, Millard, in the facts of this case, where is the scope of a DP on the same set of charges? There cannot be said DP on the same set of facts, same set of charges. Not an iota of additional material. It is simply says that means police, not even charge sheet, Millard. In police record, it is there. So therefore, Millard, Paul Anthony, GM Tangen, all these.
Where is the charge sheet? The criminal matter?
No, it is not there. No, this is the charge sheet in the DP.
No, DP we have found.
No, Millard, assuming Millard charge sheet is given, charges are not framed, then the trial court has to take cognizance of the charge. But supposing I get an acquittal in the criminal case, then what happens?
No. There are, maybe that's what we are trying to understand. Is it a case that dual proceeding should not go, therefore DP
Yes, yes, therefore DP
is it only that?
Yes.
Or is it a case that the charges are vague?
No, Millard, naturally.
Therefore, there is no scope for proceeding in this.
Charges are naturally, Millard. My additional limb of argument would be that. But principally, Millard, when my learned friend instituted this proceeding, he proceeded on the basis that there cannot be two proceedings. Charges are absolutely vague, Millard. What is the charge? There is no charge. I have indicated in my reply.
You file your whatever affidavits you want to file it immediately.
We'd like to file our affidavit.
But just a passing thought on these charges, how will you arrive at a conclusion that the person is responsible for
that is the departmental proceeding has been initiated now.
Suicide.
The inquiry committee will, Lordship, definitely.
Of course, inquiry committee, it is not for you or for us to decide. We are asking you on these allegations.
Lordship.
There's no other allegation.
Lordship. There are certain judgment of the apex court also in this regard, Lordship. There are, in some cases, Lordship, so cause cannot be challenged also. I would like to express before your Lordship one of the judgment. So, not in all the cases, Lordship. So I will file our affidavit in details, Lordship.
You file it within 2 weeks. Let them file it, then let us see. And, first, there has to be a finding that the person is responsible in some way, causing an abatement.
That as a government servant, you are guilty of doing this misconduct independently of the criminal case.
That these allegations are not there, that you are habitually.
And my suspension, Lordship will kindly, in the other case, I have challenged my suspension. Let suspension be revoked, Millard. What is there in this case? You are not proceeding criminally, you are not proceeding departmentally from July 2025, 1 year. My suspension should be given a direction, Millard, to consider my case for Millard revocation of the suspension.
So departmental proceeding, Lordship, that committee has been constituted. So Lordship, now the proceeding will start.
Heard Mr. K.N. Chaudhary, Learner Senior Counsel, assisted by Mr. R.M. Chaudhary. Mr. P. Sharma appears for the elementary education. P.N. Sharma appears for the elementary education. The respondents representing the elementary education department of the petitions. Mr. S.K. Mehdi for
I'm for responsible.
Accountant General.
I'm for SSC.
Mr. S. Bora for
SSC.
SSC,
SSC.
SSA, Sarva Siksha. Mr. Pegu for District Commission. You filed affidavit where?
In respect of item number 6011 of 2006.
In the
6011,
suspension
that is
matter.
Suspension matter.
62.
The State Council submits that an affidavit has been filed in WPC 6011. However, instructions respect of the issues in WPC 171 of 2026 has also been received. The affidavit has not been filed. It waits for 10 days time to file his affidavit, writ petition. Prayer made is allowed considering the involved. Release this matter again after 2 weeks.
18th Milad or 22-0.
Let it be 25th,
Yes.
25th of August. Mr. S.K. Mehdi and S. Bora appears in both the writ petition, as also Mr. Ping.
So that interim prayer will be considered on next day.
Interim prayer in both. Interim prayers made will be considered on the next date of listing in the event the matter cannot be heard finally. Yes.
Also, the matter here pertains to the allocation of marks, my lordship. My lordship, the petitioner herein is the father of a class 10 student who has given the board exams, my lordship, wherein for the first, my lordship, on evaluation, 2 different marks. So firstly, he was declared fail, my lordship, in science subject, my lordship. Thereafter, he gave for evaluation. On evaluation, he was declared pass in science, but was declared fail in maths, in which he has not even given for scrutiny. Thereafter, they came before this honorable court, my lordship. This honorable court interfered and stated that since they have not scrutinized for maths, you cannot go for maths, scrutiny the science subject only. Thereafter, they again did re-evaluation of the science. And each of the 3 times, this child got 3 different marks, my lordship. And he is hanging for 1 mark, my lordship. The CBSE in his affidavit has stated that they have a provision of granting 2 grace marks, my lordship, through their affidavit. And if that be the case, that 2 marks can be granted, my lordship, then this petitioner's son is only lagging behind with regard to 1 mark. So, my lordship, that grace marks can be given. My lordship, the submission on the part of CBSE is on another aspect that they can give grace mark in only 1 subject. Since they have given grace mark in maths, they cannot give grace mark in science. But this aspect, in the earlier round of litigation, my lordship, the honorable court has clearly stated, my lordship, I will take to the cases assigned to the facts, my lordship, that maths, since there is no specific mention of with regard to grace marks, no grace marks with regard to maths can be considered, and that aspect is not done appeal by the CBSE, my lordship. So, my lordship, my submission is with regard to the case of the petitioner is that if I take your lordship to my submissions with regard to pages, my lordship, if NHR 1
First,
page,
take
page
us to the earlier order.
my lordship, it starts from page, my lordship, 37,
37, yes.
37, and I take your lordship, I'd like to take your lordship from paragraph number, my lordship, 6, page number 40, my lordship. So, may I read, my lordship?
You read from para 2?
Para 2, my lordship, yes, ma'am. The case of the petitioner is that his son agreed for the secondary school examination 2025, comprising of 5 subjects, namely English, language and literature, Hindi course B, mathematics basic, science and social science. Upon receiving the mark sheet, the petitioner found that his son has failed in science subject and was given grade E. The petitioner's son in the science subject scored 13 marks in theory, 18 in the internal assessment paper. The same added up to 31 marks only, whereas 33 marks is the pass mark. The petitioner and his son, not being satisfied, applied for re-evaluation of the science paper online as permissible under the relevant guidelines of the CBSE. When the petitioner checked the verification status, there was a remark mistake communicated on subject 086, which is the code for the science subject. The petitioner's son then received the verification re-evaluation of marks results dated 25/6/2025, wherein his marks on the theory paper in the science subject was upgraded to 15 marks instead of 13 marks given to him earlier. The petitioner's son was therefore graded as D2 in science, which is a grade given to a student who passed in the subject. Subsequently, when the petitioner's son downloaded the mark sheet after the re-evaluation was done, he was surprised to find that he now failed in mathematics subject with his score as 13 marks in theory and 18 marks in the internal assessment, with a total of 31 marks only. He was in fact earlier shown to have passed in mathematics. In respect of science subject, he was not shown to have scored a total of 33 marks in both the theory and internal assessment when added together. Agreed with the same, the petitioner is before this court. The Learning Council for the petitioner submits that the petitioner and his son have sought for re-evaluation of marks of science subject only, but the respondent authorities also re-evaluated the marks given in mathematics subject and deducted 2 marks therefrom and added the same in the science subject. The action of the respondent authorities concerned not being in terms of the application submitted by the petitioner and his son, the same should be interfered with by this court. MSR Bora Learner Standing Council CBSE, on the other hand, submits that as per the guidelines followed by the CBSE, a student is entitled to 2 grace marks only. And since the petitioner's son had already been given grace marks in the mathematics subject, he is not entitled to be given grace marks in both the subjects. Therefore, the grace marks given in mathematics have been adjusted in the science subject. In support of a submission, the Learner Standing Council has referred to affidavit in opposition filed by the CBSE on 12/11/2025. I have considered the submissions made by the rival parties and I have perused the materials available on record. The issue to be decided is as to whether in re-evaluating the marks given in science paper, the respondent authority concerned can travel beyond the application for re-evaluation and change the marks given in mathematics subject. Stand taken by the respondent CBSE in the affidavit in opposition filed by them at page 6 and 7 may be extracted hereafter. After re-evaluation verification, the candidate had applied for verification in subject science 086 and +1 mark was increased after the process of verification. As per the new result, the candidate obtained 13 + 1, 14 raw marks in theory, 18 marks in internal assessment.
From 14, how did it become 33? By giving one
my lordship, there is theory and internal assessment combined together. 18, my lordship. In internal assessment, and was awarded 1 grace mark so that the final marks award was 33. 13 + 1 increased in verification plus 18 IMS internal assessment, my lordship, plus 1G equal to 33. That makes candidate declare pass in science 086. And the grace mark initially awarded in the subject mathematics, basic code 241 have been awarded in science. The fact is that as per the policy of the board, grace marks are given to the subject where candidate can pass with the minimum mark. In first result, 02 grace marks were added.
No, it's not clear. He scored prior to evaluation. How much did he score in science?
My lordship, actually there are 2 categories: theory plus internal assessment. In he scored first 13. That was his original theory. Internal assessment every time was 18. 18. So as 13 was failed, he downloaded the mark sheet. Thereafter, after downloading.
So 13 plus 18 would be 32.
31, my lordship.
13 plus?
Yes, 31.
13 plus 18, 31.
31.
What is the pass mark?
33.
33.
Yes, my lordship.
So if 1 mark is granted, then it becomes 32.
That is the issue, my lordship. What happened was that for that he did re-evaluation. In re-evaluation,
they granted 2 marks.
2 marks to me. I was declared, so then thereafter I downloaded the mark sheet. While downloading my mark sheet, I came to know that 2 marks again was deducted in mathematics. So they came with the stand that since we have given marks to you in science, we deduct.
They had given grace marks in mathematics also earlier.
No, I was declared pass.
No, with or without grace mark?
With grace.
According to them.
No.
According, this is.
I'll place the record.
With regard to their submission, they have given grace mark to us. in mathematics, 2 marks, since the CBSE has policy of only granting 2 marks, my lordship. So their stand is that they have given 2 marks to us in mathematics. So since now they have evaluated the science subject, and since they have given us pass in science, so have deducted the mathematics, which paper I have not even given for evaluation. So I came before this honorable court, and the honorable court, my lordship, this paragraph is important. May I continue with my paragraph, my lordship? My lordship, so that's my lord 6, I will start, and then 7, my lordship. From the above extract 6, my lordship, it may be seen that stand taken by respondent CBSE is that grace mark was initially awarded in the subject mathematics, and after verification of the science subject, 1 mark was increased, and hence the actual mark scored by the subject student in science subject become 14 marks, and with 1 grace marks, he would be scoring 33 marks, which is the pass mark. Accordingly, 33 marks were allotted to the student in science subject. However, in doing so, they have deducted 2 marks from mathematics subject, making the student fail in mathematics. My lordship, this paragraph is more relevant. It may be seen that as per the communication sent to the son of the petitioner on 25/6/2025, Annexure 7, the revised marks upon re-evaluation in the science subject in theory paper was 15 marks compared to 13 marks, which he had scored earlier. Accordingly, he was declared to have passed and graded as D2. There is no indication that 2 marks given to him were in the form of grace mark. My lordship, it is reflected with regard to maths, my lordship, the honorable court on earlier occasion. Therefore, the stand taken by CBSE in their counter affidavit, the relevant part of which has already been extracted herein above, cannot be accepted. Further, when the son of the petitioner applied for re-evaluation in the science subject, science paper as per the relevant guidelines, it is not understood as to why, while making such re-evaluation, marks have been deducted from the mathematics paper. Besides, as already stated in the communication dated 25/6/2025, by which the student was communicated about the deduction of the mistake in the allotment of marks in science paper, there is no indication to show that 13 marks given to him earlier have been upgraded to 15 marks by giving him 2 extra grace marks. Therefore, the marks already given to the petitioner's son in respect of mathematics cannot be changed in the manner that has been done without any application for re-evaluation of marks in the mathematics paper. Accordingly, upon due consideration, the court finds it fit to direct the respondent 1, 2, 3 to re-evaluate the marks given to the petitioner's son in respect of science subject without making any changes in the mathematics paper, for which no application was submitted for re-evaluation within a period of 1 month from the date of receipt of a certified copy of the order. The original marks allotted to the petitioner's sons as per Annexure 3 would be the accepted marks, which, however, would be subject to any changes that may be required to be done in respect of the science subject after the re-evaluation is carried out as directed herein above. My lordship, my submission is that the CBSE comes to the sense then, even by filing again affidavit in the instant writ petition also, that 2 marks they can give as grace. They are on the
In
stand.
any subject.
Any subject. Yes, my lordship. Their stand is that I have not been given this grace mark, which I presently require only 1 mark, my lordship. Not been given this grace mark because I was given grace marks in mathematics. With regard to that mathematics aspect, grace mark, this honorable court has already given its observation that this cannot be accepted, and they have not gone appeal against that order, my lordship. So my grace mark stands by, my lordship. So I am here now declared fail after re-evaluation with regard to 1 mark. So I'm praying for granting me the grace mark, because with regard to the grace mark and allocation of marks in mathematics, this honorable court has already discussed in detail that cannot be accepted, and they have not gone for appeal with that regard. So the stand of the honorable court in the earlier round of litigation with regard to that grace mark stands, and in an instant affidavit also they have not explained that in detail, or neither they have taken the
Now what is your complaint that
My
they have
lordship-
reduced the marks in maths?
maths. Now after revaluation I get now 32. Initially first time I get 31. Then thereafter I did reval. Then I get 33. Now again come to 32. So the thing is that as they say that grace mark is there.
You are saying that in para 7, the court had already held that the
Yes.
marks in mathematics cannot be altered.
Altered, and also has been observed that since they have not stated anything about the grace mark there, this cannot be accepted.
Yes.
Right, my lord. My lord, in this matter, my lord, he failed in 2 subjects. One, maths, and another is science. In both the papers, my lord, he secured 12.5 in practical paper, my lord. Maths, 12.5, we
My lord,
Your case is that he had failed in two subjects.
two subjects.
He had given grace mark in maths.
Maths,
So he secured pass marks in maths.
maths.
In science, therefore he failed.
He failed.
Now,
my
in
lord.
view of the court's order, you have given him grace mark in science
Science,
by taking away the marks from the maths,
maths,
adding it to science.
science. My lord,
Resultantly, he has failed in maths.
maths.
What do you do about the observation given in para 7?
These are computer generated. These are not manually done, my lord.
What are you going to do with regard to the observation given in para 7, page 41?
My lord, that is our policy, my lord. That if
Your policy or decision otherwise
my lord,
cannot override a judgment of the court.
but my lord, because we can give only 2 grace marks. I understand. My lordship is
If you
putting it to
understand
me.
that, why are you arguing it? There is a clear direction that the marks given in respect of mathematics cannot be changed.
My lordship. Then he fails in science. my lord.
No, there is a further direction that you give the grace marks in science.
Then, my lord, we have already given grace mark in maths. We cannot create another grace mark for science
That
subject.
you
my
should
lord.
have urged before the court earlier.
That, my lord, because that has to be, my lord. Otherwise, we cannot create 4 marks, grace marks. Grace, my lordship, may kindly see, we have in detail, my lord, my affidavit, page 60. I have the record.
See, you read page 7 and paragraph 7 and 8. There is a clear direction.
My lord.
In fact, para 8 makes it very clear that you have been directed to reevaluate the marks in respect of science without making changes in mathematics paper, for which no application is there. That's the finding.
My lord, that finding does not tell us to give grace mark in science subject.
What else does it say?
Accordingly,
you reevaluate the marks given to the petitioner's son in respect of science subject without making changes in maths.
My lord, that can be done, my lord. She can pass in maths, but she'll fail in science, my lord. He can fail in science. Because, my lord, page 60, for a moment, my lordship, may kindly peruse page 60 of my evidence in opposition, my lord. Sorry. I'm sorry, my lord. Our policy, my lord.
Why did you give grace marks in science? If your grace marks was limited, it already issued grace marks in mathematics.
Mathematics.
Why did you change your policy and give grace marks in science?
Yes, my lord.
Why?
Because, my lord, our policy says in the list, my lord, the minimum passing marks with the least addition, my lord. Minimum passing mark with the least addition. And least addition is the grace mark. Earlier, we gave him grace mark in mathematics. He passed in mathematics. He secured 12.5. We make it round off 13, then 18. We gave him 2 marks extra. And then, my lord, he passed in mathematics, 33. And he failed in science. Then he filed for re-evaluation. On re-evaluation, my lord, he secured 1 more marks. And, my lord, his total marks, it turned out to be, it
32.
was 32, my lord.
In
And
science.
as science, my lord. And as per our policy, my lord, least mark, grace mark, if we give him 1 least mark, my lord, he passed in science and he fails in mathematics. And by applying that, my lord, we gave him 1 grace mark in science. He passed in that, my lord, but he failed in mathematics.
Maths, he requires how many grace marks?
2. He secured 12.5 marks. And, my lord, we make it round off 13 marks. Then we gave him another 2 grace marks. Then he secured, my lord, 33 marks in total. And science also, 12.5 marks. We make it round off 13 marks. And, my lord, on re-evaluation, he got another 1 marks. That is 14, my lord. By applying our policy, my lord, that minimum passing marks, my lord, that is 1 marks, my lord, we passed him in.
What is the internal assessment in maths?
18.
18, my lord.
18.
18.
So 18 plus, according to you, 13.
Page 60, if my lordship may kindly peruse, my lord. This was given to him. Calculation is here, my lord, clear.
60?
60 of my affidavit
60.
in opposition, 60, my lord. Annexure 3.
60.
60, my lord. The fourth para, my lord. After scrutiny of the results, records and related correspondence, the following points are noted. The candidate Master Manavjyoti Vishwakarma had originally obtained science 13 marks in theory plus 18 marks in internal assessment, 31, that is fail. Mathematics basics 13 marks in theory and 18 marks in internal assessment plus 2 grace marks, 33, pass. He passed him, my lord. Then hence his overall result was declared as compartment. Then, my lord, after the process of verification of marks, 1 more mark was increased in science theory paper, thereby raising the total of 14 marks in theory.
No, what is the increased mark?
1 mark, my lord.
What is the increased mark?
1 mark, my lord, in re-evaluation.
Re-evaluation.
My lord.
That is in science.
Science, my lord. 14 marks.
Okay.
So, my lord, para
Then
3, my lord.
you add 1 more grace mark,
Grace mark, my
making it 15
lord. My lord.
plus 18.
18, 33. This one, my lord, para 3 it is written, my lord. As per the CBSE grace mark policy, grace marks are awarded only in subjects where the candidate can achieve minimum passing marks with the least addition. Accordingly, 1 grace mark was awarded in science, making it 33 marks in total. 14 plus 18 plus 1 grace is equal to 33. Thereby, science was declared pass. Now, page 61, my lord. Since grace marks are limited to a maximum of 2, the grace marks earlier given.
But how do you come out of the direction of para 8?
My lord.
Para 8 direction is very clear. You re-evaluate without making changes to the marks in mathematics.
My lord. Then, my lord.
How have you done it?
This is my lord. The clarification is given at page number 61.
Clarification is okay. If this clarification is there, then you should seek clarification from the court.
My lord.
So what will be the effect of the direction in para 8?
My lord. Because, my lord,
you can't override a direction of the court. If you think it is not, it is in conflict with the rules, then you should come back to the court seeking a clarification.
Because, my lord, it is system driven.
System driven or otherwise, but we read whatever is there in the court's order. Court's order is very clear. Re-evaluate the marks in respect of science subject without making any changes in mathematics. This can only be read and understood to be that, nothing more. If you insist that whatever you're doing is in tune with the direction of the court,
my lord,
prima facie it appears to be contumacious.
But, my lord, this is not with regard to the grace mark, my lord. This is with regard to the re-evaluation.
Why you trying to read anything more than that is there in the order?
My lordship, that is
the order of the court
finding,
is clear that you will re-evaluate the marks given to the petitioner's son in respect of so and so without making any changes in the maths. You decide what it means.
Re-evaluation, my lord.
You decide. You pass. You pass orders on that. If you think that it requires clarification, you know the process for getting clarification.
This is re-evaluation.
That's right.
Re-evaluation, that is so far my lord, secures mark, my lord. This is the grace mark policy.
The direction in para 8 has to be read as a part of the entire order.
My lord.
The intent of the court's order is that there was no application seeking re-evaluation in mathematics, therefore you can't change it. You keep the number in mathematics constant and you re-evaluate the science, which according to you, you have already done it.
My lord.
You are already re-evaluated.
No, my lord. Re-evaluation only in respect of science.
That's right.
But in respect of maths, my lord, he secured 12.5 marks. 12.5 marks, we make it 13. 13 is intact, my lord. Only, my lord, grace mark comes down to science, my lord, in place of mathematics. We have not touched anything, my lord, with regard to her. We have not re-evaluated the paper of mathematics. I have the records, my lordship, may kindly peruse the record.
No. If you bring down the marks in mathematics,
My lord,
automatically it gets re-evaluated.
but the case is we have re-evaluation with regard to the marks secured by the petitioner, my lord.
That's right.
Petitioner's son. We have not re-evaluated the paper of the petitioner's son, my lord, in mathematics. We have re-evaluated the paper in the science, my lord.
Whatever term you use,
My
the
lord.
effect is that there is a re-evaluation undertaken in mathematics, which is prohibited by the court's order.
That is why I'm submitting, my lord, it's system-driven process, my lord, entire thing.
We are not an appellate court.
My lord.
Either you prefer an appeal, you file a review, or you comply with this order. I don't think it requires that kind of arguments,
my lord,
to drive home this point.
My lord.
So this is a clear order of the court.
My lord.
If you're aggrieved, you know what forums are there.
My lord. Earlier counsel didn't point out this aspect, my lord,
We don't
but this
know
is
who
the
did-
most
who did
important
what. We are
aspect, my
going by
lord.
the court's order.
My lord.
This writ page now, what is your prayer here in the writ petition?
My lordship, my submission is that according to their stance, they should, my lordship, they have 2 grace marks in hand. I require only 1 grace mark, my lordship. So I presently, my lordship, because my lordship may kindly see, I got 32 because as per course order, my lordship, in the course order, my lordship, they have clearly stated that 2 grace marks they can be given. My lordship, I am not aware as per records whether they have given or not, but the honorable court has clearly stated in paragraph 7 in the earlier round of litigation that those 2 grace marks cannot be considered. Observation is clearly.
That is why I was directed
my
to
lordship,
place the records.
paragraph numbers.
And I have
My lordship, my
asked the
submission.
CBSE officials to bring the record.
My lordship,
So
whatever.
records to
Whatever the record.
for what purpose?
My lordship, whatever the record, my lordship, my submission is that earlier round of litigation, they have stated that they have given 2 grace marks, since they can give 2 grace marks in mathematics. The court has clearly stated, which they have not gone for appeal, that these 2 grace marks cannot be considered. So automatically it lies that 2 grace marks are still alive. And here presently after re-evaluation, I only need 1 marks, my lordship. So since they have 2 grace marks in hand, I may be going and declare pass. My lordship, this son of the petitioner, since 13/5/2025, the son of the father is a driver. Right?
That is not correct, my lord. My lordship may kindly peruse the record, my lord, for a moment. We have already granted grace mark in mathematics.
So that
and
cannot be granted.
evaluation has not been done in mathematics, my lord.
My lordship, that cannot be given.
I understand what my learned friend is submitting, my lord, but the submission that 2 grace marks are there with us, my lord. That, my lord, I cannot concede to be correct, my lord, because
If you cannot, then you get this order corrected.
My lord.
What else do you want from this court?
My lord. My lordship, may allow us some time in the meantime, my lord.
Is there any prayer made that you want some time until now?
No, my lordship, affidavit is
For the past 15 minutes, that's what we are trying to make you understand. You are producing the records.
My lord. Because, my lord, that grace mark point is been assailed by the petitioner side, my lord. That is why I pray, my lord, that
this was
some
for first
time
day
may be allowed.
submission and my lordship, they have
Because we have to get the earlier order rectified, my lord. I understand.
Counsel for the parties, the standing counsel for the respondents. Submits that they have acted in terms of the directions contained in the order passed in dated on 3/2/2026, passed in WPC 5536 of 2025. By the said order, the following directions were issued: para 789, 6789. Stop. Para, from a reading of these paragraphs, it is clear that the direction of the coordinate bench was to re-evaluate the marks obtained by the petitioner in the science subject without altering the marks obtained by the petitioner in mathematics. Stop. Whereas the grievance of the petitioner before this court in the present proceeding is that, notwithstanding these directions contained, the respondents have re-evaluated the marks given to the petitioner, the petitioner's son, for the science subject but had altered the marks in mathematics and thereby the petitioner cleared, obtained the passing marks in science subject, but did not obtain the passing marks in mathematics. So this resulted because, according to the petitioner, 2 grace marks were already added to the mathematics marks obtained to the marks obtained in the mathematics subject by the petitioner, whereby the petitioner secured the passing marks in mathematics. However, in view of the order passed by the court, by the order dated so and so in WPC so and so, the marks required to be re-evaluated for the science subject was undertaken by allotting the grace marks. Stop. According to the petitioner, according to the respondent department, the department is the department authorities, the respondent authorities are only empowered to add 2 grace marks, and therefore the same having been already added in mathematics, the student was earlier considered to have failed in science subject, but in terms of the court's order, if the student's marks in science subject is required to be re-evaluated by adding the grace marks, then the grace marks already applied to the science mathematics subject will have to be altered, and the consequence thereof, the petitioner's son will not secure passing marks in the mathematics subject. The counsel for the petitioner has placed the records before the court to substantiate his arguments that they had complied with the court's order. However, on considering the submissions and upon a plain reading of the court's order, it is seen that there is a clear direction by the coordinate bench to re-evaluate the marks obtained in the science subject without making any changes in the mathematics paper, for which no application was submitted for re-evaluation. Stop. This being the clear direction of the court, the respondents are duty bound to carry out the order in terms of the directions contained. Stop. A judgment or an order of the court is to be read for what it is. No further interpretation is called for. Refers to judgment. Better. Under such circumstances, this court is disinclined to accept the submissions of the counsel for the respondent that they have taken steps to comply with the court's order. At the cost of repetition, it is to be stated that the direction of the coordinate bench is very clear that the marks obtained in science are required to be re-evaluated without making any changes to the marks obtained in the subject of mathematics. So if that be so, then the respondents are duty bound to re-evaluate the marks and add grace marks as applicable to the marks already obtained, by the petitioner's son in the science subject without there being any alteration in the marks obtained by the petitioner's subject on the date shown to be obtained on the subject of mathematics on the date when the order dated so and so was passed in WPC so and so by the coordinate bench. So this order has attained finality as there is no review or an appeal filed by the respondents or any application seeking clarification of the directions contained in the order. Accordingly, writ petition stands disposed, issuing further direction to the respondents forthwith carry out the directions contained in the order dated so and so. Within a period of 30 days from the date of 15 days from the date of receipt of a certified copy of this order.
Their prayer is evaluate, my lord, science without touching upon the maths, my lord. That grace mark we have already granted, my lord. We can reevaluate the science subject, my lord.
Whatever you want to do, you do
But
it
grace,
for this.
if my lordship directs us to consider the grace mark with regard to the science, my lord.
We cannot do that in view of the court's order. You are asking us to interpret the court's order.
No, my
We
lord,
will not
that
do
part is, that part remains, my lord. This is a separate litigation, my lord. But continuation of the earlier
That's
litigation.
right.
That
You have to
mathematics,
satisfy as to how the court's order has been complied with.
my lord.
You satisfy us from your records that you have re-evaluated without making changes in the marks allotted to mathematics.
That my lordship can, my lord, anytime alter our, my lord, that stand, my lord, and give us a direction, liberty to ascertain the, my lord, revolution of the
Why should we
science,
give you
my
a
lord.
direction? We are stopping short of drawing contempt against you by converting this petition into a contempt petition. There is already a direction of the court. You set over this. You do not choose to file an appeal. No review. No application seeking applications. You are coming before coordinate bench seeking clarification.
No, my lord, that is.
Is it permitted
not
under
I'm
the High
saying,
Court
my lord.
rules?
What I'm submitting, my lord, is that there is an order, my lord.
Yes.
And that order says without touching upon the mathematics, my lord. My lord, I'm persistently submitting that this is a system driven, my lord. I understand. But their prayer is, my lord, that that observation, that finding we have attained, my lord, that altering the science subject, that is with regard to policy decision, my lord. Only because the policy is there, my lord, that is why couldn't, my lord, we couldn't touch that, my lord. Now is the situation, my lord, the honorable court may direct us to reevaluate the papers, my lord, we can do it, my lord.
Only direction is there.
But grace mark, my lord, observation, if grace mark observation is given, my lord, that 2 marks already we have given grace mark. Now, my lord, another 2 grace mark in science, my
Mr.
lord.
Counsel, one more submission, one more word. We are issuing notice of contempt against your respondents. We are making it very clear. You are stretching it too far. Don't do it. You know the procedures.
My lord.
You are not remediless. Go and choose your remedies.
Obliged.
Don't insist on things which are not permissible.
My lord.
My lordship,
Yes,
we can
boss.
process. My lordship, in one paragraph, my lordship has written in third paragraph of fourth, it should be petition, respondents, not petition. Obliged, my lord.
Can it be 30 days, my lord?
No, 15 days.
Deeply obliged.
No affidavit.
Regarding one part of alia has been released. For another part, lordship, one proposal has to be moved from director to say, government lordship. And director sought for 6 weeks time for this lordship.
What
Last
6
paragraph.
weeks time? Why do you want so much of time?
Lordship, that budget approval and budget proposal is to be made, lordship. That's why, lordship. That instruction.
What is your prayer here?
Yes, my lord. For area, my lord.
Area salary.
Area salary. One part
We'll
has
give
already
you
been
4
released.
weeks time to comply with the directions contained in the order. Heard, learned counsel for the parties.
There was no direction, lordship. There was no direction.
What direction?
There is no direction, lordship.
We'll give you 4 weeks time to comply with the, file your affidavit.
Yes.
The claim of the writ petitioner is for area salary. The standing counsel, Mr. Huh?
If instruction has come for this,
Instruction has come to pray for further time. You want us to dispose it off, we can dispose it off.
further time, my lord, for evidence. If they, my lord, they admit our, my lord, claim, my lord, maybe dispose of giving release the amount, my lord.
Affidavit on delay admit hobo na.
Yes. You want a disposal? Third counsel for party. The petitioner before the court has claimed are serving as graduate teachers on contractual basis in different senior madrasas. Subsequently, these madrasas were converted to high school. Till such conversion, the writ petitioners were receiving their salaries. However, the petitioners were given their regular scale of pay only with effect from March 2022 instead of 1st of January 2022, which according to the petitioners, they're entitled to. So, accordingly, the petitioners claim that their area salary be released for the months of January and February 2022, and also for the periods October 2022 to February 2023. This the petitioners respondents have not done in spite of the representations filed. Did you file any representation?
No, my lord, not, but director forwarded my lord, the proposal to the government page 79.
In spite of
Page 79.
79.
Yes, my lord.
In spite of the proposal being forwarded to the secretary to the government of Assam as far back as 3rd of March 2023. So, the Standing Council, Secondary Education submits that
Paragraph 6.
the process for verification of the presence of 140 numbers of erstwhile madrasa additional contractual teachers in their respective schools during the period 1/10/2022, 28/2/2023 is required to be undertaken, and upon such verification, steps will be taken for processing the area salary and for submitting a proposal to the government for obtaining sanction. Stop. It is further stated by the learned Standing Council on the basis of instruction, the release of area amount is therefore attributable to non-availability of adequate budget provision and not due to any deliberate inaction on the part of the director.